हेलो। सुनने से होता है। ओके ओके। ओके सर। नहीं सर। हाँ।
Lord, fresh matter, MFA arbitration, my lord. Fresh matter. Day after tomorrow, Friday. ಇದೊಂದು ಯಾವಾಗ ಕೊಡ್ರಿ.
ಕೊಡಿ.
tomorrow ನಾಳೆ free ಇರುತ್ತೆ.
ನೋಡ್ಕೊಂಡು ಹಾಕಿ.
Lordship, appeal is filed. Demolition matter. Senior counsel will engage the matter tomorrow, Your Lordship.
You don't say senior counsel, you will say put it tomorrow, I'll put it. If
Okay.
the senior counsel, I'll reject.
Okay. Apologies.
Tomorrow. All scrutiny, etc. must be complete.
Page-wise adjournment. Page number 8, till number 22 to 25.
Lord, serial number 22, my lord, is compassionate appointment matter. We taken on Monday, my lord.
ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಅಂತ
ಏನಿಲ್ಲ ನಾನು ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದೆ.
ಹಾ?
Go through the other judgments also there, my lord. Monday it may be taken.
Now there are 2-3 issues.
Yes, my lord.
One, the mother no doubt may have given within 1 year,
Yes, my lord.
but the son's application is given in 2016. That gap you'll have to explain. Now she immediately after death within 1 year she has given.
Yes, my lord.
Between that and 2016 or 17, that time gap you'll have to explain.
Yes, my for that, my lord, there is sufficient reason to say that, my lord, why there is a delay, my lord.
Why
Because
he-
my lord, suit OS and thereafter appeal RA.
Because the rule says within 1 year. If he has attained majority, that is the reasoning of the tribunal. If he has attained majority as on the date of within that 1 year, he should have given instead of the mother giving. You keep it in mind, let us.
Please.
And finally, Apex Court judgment says, irrespective of at whose end the delay is, after the crisis has passed away, irrespective of delay at whose end. That's what that judgment
Yes,
says.
my lord.
That these 3 points you must answer.
Please.
Monday.
Page number 9, till number 26 to 28. Page number 11, 29 and 30. Page number 12.
Sir, 29, man. Serial number 29, my lord. 29.1, my lord, your lordship is directed to the other side to take notice, my lord. But copy is not served to him, my lord. I'll serve the copy today only. Lordship have it next week, my lord.
Copy to be served on the appellant in 29.1. Copy to be served on the respondent. Copy of the appeal memo to be served on the respondent in 29.1. Relist the matter. 30th.
Page number 12.
My lord, serial number 31, sorry.
31 to 33.
Serial number 32 BL for Preeti Patil, but second set ಹಾಕ್ಬೇಕಂತ sir, single bench ಇತ್ತು. Next week any date.
31.
Yes, man, 31.2. Second set ಹಾಕ್ಬೇಕು sir, Preeti Patil.
Relist
One date may be given notice.
on. Relist on 29.
Macho.
Page number 30, till number 34 to 39. Till number 40, 40 to 43. 50, 44 to 47. 60, 48 to 50, 70, 51 and 52. 80, 53 and 56. Serial number 1, non-compliance of office objection. First time, Moga Sudhakar Rao.
Weeks time granted for necessary compliance.
Serial number 2, Vinayak Apte.
Weeks time granted at request of the appellant.
Serial number 3, Ramachandra K.
Weeks time granted to do the needful.
Serial number 4, Ravi B. Patil.
I have paid the process yesterday, my lord, in the office.
Counsel.
and Permitted to, my lord, file a memo seeking
Fine.
extension of.
Counsel for the appellant. Submit process has been paid in the office.
Yes.
Memo filed seeking extension of interim order. In light of memo filed and submission made, interim order earlier granted is extended till the next day.
My lord, I have carried out the amendment also, my lord, the memo dated 18/1/23 may not survive for consideration in view of a fresh memo filed on 20th, my lord.
Memo dated 18/1/2023 is disposed of has not, is disposed, memo dated 18/1/2023 is dismissed as not pressed.
Notice as,
Amendment of cause title of appeal is stated to have been carried out.
yes. Notice to the fresh address which is furnished, my lord, as per the memo.
So issue notice to R7 to the fresh address furnished in the registry.
Please.
Yes.
Number 5, HA.
Amount, my lord, on 16/1 amount is deposited as per the directions. On letter ಕಳಿಸಿದ್ದಾರೆ. They are
serial
ಕರ್ಕೊಂಡು-
number 5, 28, 54 and 55. The
Five?
same 5, serial number 5 minutes. 28,
54 and 55.
54 and 55. The same kind, the same notification, same village, same purpose, common award already the appeals were dismissed by the court. This honorable court. Disposed files are kept in
May-
the serial number 28, man.
These matters are,
These for the same purpose, same notification and the common award, it's already the appeals were dismissed. And my crops, I withdrawn the crops, man. So,
My lord, these
Sir.
appeals are dismissed on the point of limitation under the new act.
ಇದು ಮಾಡಿದೆ ಅಲ್ದೆ. Similarly, the award passed by the
Deposit.
reference court is already satisfied in some other cases and they prepared the appeal in the
ಕೆಲವೊಂದು appeal ಮಾಡಿದ್ರೆ ಕೆಲವೊಂದು deposit ಮಾಡಿದ್ರು.
Satisfied.
there is observation in the judgment. Further. Para further.
now, in these matters
Yes.
which were disposed of, relate to survey number 11 to 14. One. Relate to.
These LAC 2, 2, 14, then this one, other, they have satisfied these amount, my lord, which is enhanced by the reference court. The same,
Now, the coordinate bench order that you have produced
yes, ma'am.
relates to survey number 30/2 plus 3A, 18/3D, 12/3 and 12/2. Isn't it?
These are the survey numbers
In
in the
those-
LAC number 1, 2, 14 and 15.
Correct.
There's the reference court award has been satisfied by the government. The same notification, same common award, the same purpose and the same village. Therefore, these appeals were dismissed. Today, these appeals were posted, by the same, common award, these in the same award and the same village and the same purpose. Those, that day, these appeals were not posted.
Like survey number.
Survey numbers are different, landowners are different. But notification, award, purpose, everything is same. And out of those, for these reference award was satisfied by the government. And when the pick and choice method, they prepare the appeal. Therefore, by hearing at length, my lord,
What do you say? What do you say?
Yes, my lord, in some matters, they have satisfied the reference court award.
Correct. Now, their contention is same village.
Yes, my lord.
Though the survey number may be
Yes, my lord, they are covered in the same notification.
same village.
When the same notification is there, one person was satisfied and some appeals are
And
filed.
it is their assertion that all are similarly situated,
Please.
all agricultural lands.
yes,
Nature of lands that is subject matter of the present appeal
yes,
is,
dry land,
is
same,
similar
yes, similar.
to those matters. So then
The
what?
same village, my lord, verified in the
Same
file.
Ah.
The disposed appeals were kept below in the serial number 28, my lords.
ಕೊಡಿ. ಇವಾಗೆಲ್ಲ MFA ತೆಗೀರಿಯಲ್ಲ ಅದು 5285455.
201.
We'll take it by 12:30.
201,002.
By 12:30 you come.
Yes, my lord.
Ask them to keep it open.
Yes, ma'am.
Now you have to, the lands, we will take it. In all the cases are dry lands.
Yes,
And you must tell us the village.
yes, ma'am.
And
yes,
then
ma'am.
I'll dictate it. I'll
Yes,
dictate it.
ಎಲ್ಲ
You just tell us the village.
Yes, ma'am.
ಕಗ್ಗೋಡು
Kaggod village, yes.
Huh?
Kaggod village.
ಕಗ್ಗೋಡು
That
village.
you just point.
The entire order is maintained in 201,002 of 22.
20
100 of 2 of 22.
MFA.
MFA ದಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಇದಾಗಿದೆ. ಅದರ ಒಂದರಲ್ಲಿ ಮಾತ್ರ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್ ಇಸ್.
May I make a submission, my lord, on behalf of the government, my lord?
Just a minute. Just a minute.
Madam, display.
Now it's a common award.
Common award, ma'am.
Reference is
Common award, reference are different, different.
different.
Yes, reference numbers ಎಲ್ಲ
I tell
different.
you award ನಮ್ಗೆ ತೋರಿಸಿ.
Yes, ma'am.
ಒಂದು.
Yes.
And then you show us the village.
Yes.
And then it's in the vicinity of these land.
Yes.
Those 3 points just show us, will dictate.
May I make a submission, my lord?
Yes,
May I make a
yes, yes.
submission in this case,
Yes.
my lord?
Yes,
My humble submission, my lord, my lordship is the same survey number and the same land also. It's a different in the rate way considered. My lord, we are handling the case KNL, my lordship, we are appeared before your lordship. There is the KNL is become a party before your lordship. In that, we have taken the stand that even same village, same notification, and it depends on the soil where it is the cultivation is made and the crop which has been made, that based on that only the compensation is the granting. My lordship, once it's ordered by this division bench order, same village, same notification, it will be heavily affected for the state revenue for concern of other cases also, my lord. My humble submission, my lordship may be we are bound by this honorable court where the prima facie we have no other option. My lord, individually the lordship may be pass an order based on that, but it's the same notice, same notification, and it is affecting for other cases also, my lord, the covered judgment on that. My humble prayer, my lord, my lordship is aware that the road side of the value, even the commercial.
now what you do, now.
My lord.
No, just 1 minute. We'll take care of your interest. Now it is, in each of the case, can you make a chart?
Please, ma'am.
You make a chart.
Yes,
And then in that chart, you say Itari RTC,
yes, ma'am.
exhibit number of the RTC, whether it is dry land. And then in these cases, whether it is dry land. So in the same village, nearby survey number, you mention that. We'll refer to that and pass.
Please, ma'am, I will prepare chart, ma'am.
Ah.
Comparative chart ಮಾಡ್ತೀನಿ. Where they are satisfied the award amount.
Correct.
And which survey number, nature of the land,
Correct.
and exhibits also common, my lord. Even
Yes.
the more thing is exhibits,
So-
example is also common.
So that you.
Even there is example is a common, they can't take such a shelter after satisfying the others award passed by the reference court. Now they can't take such shelter. It is not tenable.
Not denying their entitlement.
No,
that
we'll
we are not
consider.
denying.
We'll
But
consider
only
it
thing is,
individually.
it should
We'll
not be,
consider it individually.
5,000 crores is affecting for the
ಅದು
KNL.
ಎಲ್ಲೇ award ನಲ್ಲೇನೋ ಬೇಕಾ different fix ಮಾಡಿದ್ರೆ that is different. ಎಲ್ಲೇ award common, ಎಲ್ಲೇ award is
Correct.
common.
Now
No,
you-
the matter
Yes,
of
I
appeal,
will check.
proving
Make
that
a
you are
chart.
entitled court is
Refer
there,
to
we
the-
are not disputing.
And
Should
we'll
not
do
be
it.
a universal order, same
Yes,
notification, same amount.
Yes, yes. So you prepare a chart
Please, ma'am.
and which LAO award is with respect to which survey numbers, common award. Reference in these cases.
Yes, ma'am.
Filed, what is the amount given? Then your case, what is the nature of land?
Please.
Similarity. In case village map is marked in any one, if it is, or you can get it. village map. Then it will be easy to see the location also.
My lords, my submission in the village, when the common award is passed, my lord, they can't, in the same village, they can't differentiate when the award is passed in common. And the same, in the reference code, they are satisfied. Now they can't take such a shelter that this evaluation is different. If that is different, my lord, they would have passed the separate awards by fixing the separate rates.
We are with you now. We are with
The
you.
opportunities before your lordship, my lord, we want to
No,
do
we'll
establish.
No, we'll pass separate order.
Please,
We are
please,
with
my
you
lord.
on that.
Please.
If it is possible to get the village map, if it is possible, you also see if you can get the village map, Tengli. Village map sigata you get. In the village map, what in the pencil, you can show. Survey numbers will be marked. Idukku adukku elli hatradalli.
They have not taken any such a contention in anywhere in the reference code, either before or the reference code. Now they making such a new.
No, we'll, so you make a comparative
Yes,
chart.
I'll prepare. I'll prepare. My contents, my submission is, my lord, when they pass the common award, they can't, such a statement is not tenable. But the LEO has passed the common award. If it is a different award, my lord,
The
fixing the
price
different
fixed was-
valuation.
Price fixed by the LAO was
LEO is common.
same.
Same, my lord. No, therefore that is.
Now they can't make.
They
such-
can't take such a, this is the well-known.
My lord,
principle.
that is the
Well-known
lower
principle in the
authority.
land acquisition, my lord. If they fix the common, pass the common award in the same place, they can't. At this stage, they are stopped from these submissions.
My lord, the concerned about the lower authority is not binding only the party, but concerned about this lordship judgment, it will be universally applicable for all the case. So that is what my prayer, my lord. It should be their entitlement. If lordship has decided enhancement, so that, my lord, depends on the individual. That's what my humble prayer, not universally
We'll
same
take note of-
notification.
We'll take note of the individual location of the each land. Will take note as a.
Please, ma'am, that is my humble submission, my lord.
We'll take note of list 5, 28, 54 and 55. List 54, 55, 28 with serial number 5. On, when do you want it, madam?
29th, next week.
On 20.
We'll prepare a chart and.
On
Well,
29.
in advance, I'll serve the copy of other side.
On 29.
Please.
We will
Much
look at your chart and dictate. We will not look into the file.
Sorry. Yes, my lord, same, yes, I'm assisting the court, my lord.
Yes,
I'm
yes,
not taking any
yes.
such.
We will also get opportunities, my lord, to be encountered in that. If it is as a matter of respondent.
On that
Ultimately,
point.
land losers
in
will
the-
get the benefit,
No,
advocates.
in the
Yes.
event, you can get any one authority where a common award is passed. You place it so it will.
Please, my, I'll furnish.
Right.
It is well settled, my lord. When the common award is passed, my lord, they can't. Yes.
Idli.
Sorry. 20, date 29.
29.
Please.
Serial number 6, Veeranagowda Madipati.
The award amount has been deposited before the reference code.
Huh?
The 50% of the award amount is deposited before the reference code. We will file acknowledgement for having deposited. The office note is that we have not filed acknowledgement.
You have paid. You have deposited.
On different date, it is paid.
That's okay. In terms of the interim order, you have
Paid,
deposited.
paid.
Now get ready on the main. Get ready on the main.
Please, my trial court records have not been secured.
To issue reminder regarding TC non-receipt of reminder regarding TCR positioned by this court. The counsel for the appellant submits that necessary memo would be filed with details of deposit made before the reference court in terms of the interim order passed. Relist the matter. Date could list. ಇವಾಗ ಬರೀ 6-7 matters ಇದೆಯಾ ಈ ಬ್ಯಾಚ್ ಅಲ್ಲಿ?
ಇಲ್ಲ, still there are other matters. I'll furnish.
Counsel for the appellant to file memo regarding details of. No, you furnish it to the court of. List MFA so and so along with the present batch of matters. You must give it to the court office.
I will inform.
Same project, whatever cases
Please,
are there,
please.
you tag it along with list. Relist on date could. 31st.
Please.
Serial
Yes.
number 7. Deepak V. Bharat.
This, Lord,
Yes.
Lord, this contempt and writ appeal, Lord. Lord, the contempt has filed by the complainant. Lords, earlier. Lord, earlier occasion, my lord, I had taken adjournment, my lord, since a connected matter was pending before the Supreme Court on 21st, my lord. It has not yet reached, my lord, on 21st. It is again now listed on 28th, my lord. 28th. Since, my lord, the order effect, if passed by the Supreme Court, it will be affecting this matter also. If it is in my favor, this matter will be allowed directly. My lord. If
On
it is,
what point matters
my
pending?
lord, sir, now this, I had made an application for single layout before the authority, Urban Development Authority. They didn't consider my application. Thereafter, my lord, I had approached, approached to the learned single judge. Learned single judge directed the petitioner, respondent authority, within 6 months, they had the application for single layout has to be considered. Thereafter, my lord, they preferred writ appeal. In writ appeal also, my lord, the learned single judge order was confirmed and penalty was imposed on the complainant herein for 5 lakhs, my lord. Since, my lord, I had constructed a function hall on agricultural land at the first instance. Thereafter, I had a demolition order was passed by the deputy commissioner. Deputy commissioner, my lord, order was challenged before the learned single judge. Learned single judge directed that, my lord, the duty compounding charges has to be taken and NA has to be issued to the petitioner. I had paid the compounding charges and penalty. Thereafter, further observation was that, my lord, I have to obtain ex post facto construction permission. In order to obtain ex post facto construction permission, my lord, single layout is necessary. Then, my lord, I had made an application after obtaining any order, my lord. Then I made an application before the Urban Development Authority for single layout plan. My lord, they did not reject my application, neither they have given any endorsement. Only they orally suggested that, my lord, half of my layout comes in a residential premises, half is on commercial, my lord. In order to get the layout, I have to get change of land use. Thereafter, my lord, I have made an application for change of land use. On the recommendation of the authorities, the government made the change of land use in my favor. Again, once again, I approached the authorities, making a fresh representation for reminding the earlier application of single layout, but that was not considered. I approached the learned single judge. Learned single judge gave 6 months time and it was not considered. They challenged that order before this honorable court, the division bench. Division bench, my lord, and again, I had filed a contempt along with the writ petition, writ appeal. In both the common order were passed that the application has to be considered within 1 month, and I was imposed 5 lakhs penalty, my lord, since I had violated some rules in the non-agricultural land, and I had paid that 5 lakhs also. That order is challenged before the Supreme Court. In the meanwhile, my lord, before any notice were issued by the Supreme Court, I made an application before the learned single writ petition was filed by the complainant, contending that, my lord, if the application is not considered within 6 months, deemed permission is granted. That writ petition was allowed, and I had filed a contempt before this court. This contempt, my lord, contending that, my lord, assembly charges and penalty has not been taken by the respondent authority. I am ready to pay the everything. Since, my lord, why I am filing this contempt is, if at all any approved layout is not sealed, subsequent issues by the authority, I cannot get ex post facto permission. For that purpose, I had filed a contempt. Now, my lord, the earlier order of this writ appeal is challenged before the Supreme Court. It is pending before this 28th. That's the only issue.
Let us,
My lord, here
let us see what happens to that.
in Supreme Court, yes.
Relist the
If
matter.
First week, my lord, since, my lord, the earlier honorable judge has retired, on whom admission was.
Second week. Second week. 11. Yes, next.
Serial number 8, 11th February. Serial number 8, Ramachandra K.
Yes.
Respondent number 3 not served the copy. They have filed again a revised affidavit, my lord.
They are not considered the single judge order, my lord.
What is the direction? Then copy ಕೊಡ್ಬೇಕಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
Third respondent.
Third respondent, Chandrasekhar Dasankar.
One name, Lordship issued the bailable warrant to the
He had come.
third respondent, my lord. Thereafter, my lord, he appeared in the,
He appeared.
I don't know, that is, my lord, what happened thereafter, my lord. Today he knows the date also, my lord.
Passover.
Awesome.
Number 9. Kadluru Satyanarayanacharya.
My lord, I seek time to take steps in
Time
respect of.
granted to take necessary steps. So far the deceased. Respondents are concerned. Yes.
Till number 10. Hema L. Kulkarni.
But in this matter, my lord, additional advocate general is appearing.
Passover, my.
Or this matter.
My
my
lord,
lord,
in this case, my lord, in this case, my lord, as in order to be complete the lordship order to the allotment of the site at supermarket Kalaburagi, my lord, in order to be complete the order, my lord, we have been approached. My lord, we have been approached this National Monument Authority
No, correct.
to
Now.
fix the border of the fix, my lord. I will take 1 minute of your lordship, my lord. This supermarket property was being auctioned and
No, Ms. Mallarao, we are aware of the facts, but
My lord.
last time, this is that allotment, isn't it?
Yes.
We
for
said
the
affidavit.
allotment,
What is the
that-
procedure? What is the procedure? File an affidavit we had asked.
my lord, in the other case, the affidavit is asked, my lord, but in this case, my lord, in this case, my lord, the allotment, they are agreed. They are not disputing with regard to what we are allotting. To allot that, my lord, we wanted to get a concurrence, the report from the Monumental of National. Because once we are allotting, last time they are only disputing. That is the reason we want to fix their border. After that, what remains land and that, within our limitation of the land, we are going to be allotting for them. That is the reason. We are requesting to the National Monument Authority to fix their border, and remaining land we are going to be allotting them. It is in the process in order to be complied the condition of this lordship, my lord.
No, so to that effect, you file an affidavit. What is the steps taken? We'll record it.
Please, my
Whatever
lord.
steps, we'll have it next week. You file
Please,
an
my lord.
affidavit as to what steps you have taken to demarcate the boundaries.
For the demarcating, we need to be a border has to be fixed from the National Monument Authority, my lord.
So file an affidavit for
Please,
what
my lord.
steps you have taken for demarcation and what is the procedure that is going to be followed eventually.
Please, next week I will submit it.
Let them file affidavit.
Please,
Affidavit
please.
to be filed by the respondents as to the procedure that is being followed for the purpose of making allotment.
Much obliged.
Relist on. Yes.
Number 7.
29th, my lord, 29th is given the other matters, 29th. So
29th,
that
29th.
much
Yes.
obliged.
Tesh Patil.
In this matter, last date of hearing, other side was directed to get instructions, my lord, sir.
But in this matter, my lord, appraise a week's time, my lord, because my lord, our officer, my lord, issued the endorsement. My learned friend did so.
On the face of it, the endorsement, my lords, which is already set aside the same reasons quoted, and this honorable court, my lords, in a writ petition, has gone into the merits of the endorsement and set aside which is unjustified. Thereafter, again, the same reasons were quoted and same endorsement is issued.
69, my lord, page number.
So what was the earlier order?
Earlier, my lords, endorsement is at page number, typed copy is at page number 25, my lords. Last paramex.
No, what is the observation of the court? Tribunal.
Just I will brief more of the certain facts. Wherein the petitioner, my lords, the father of the petitioner was an government employee working in the fourth respondent, my lords. Was died on 14/2/2019. Thereafter, my lord, the petitioner sought my lords appointment on compassionate ground. That her claim was rejected on 6/1/2020 on the ground that my lord, she is a married daughter. Then the petitioner has filed filed an application, my lords, before the KSAT. The KSAT quashed the endorsement, my lords, on by relying on the Bhuneshwari judgment, my lords, wherein the word of married was been struck down as unconstitutional. Then, my lords, I approached again the authorities. They did not, my lords, comply with the order. I filed a contempt petition before the KSAT. In the KSAT, they have issued the endorsement stating that, my lords, by virtue of the 2021 rules, and those has to be applied prospectively and not retrospectively. Therefore, I am not entitled. That was the endorsement and reasons quoted, my lords, relying on the one judgment of the Supreme Court, my lords. Thereafter, I challenged that, my lords, endorsement before the KSAT in application number 20744/2022. That my application came to be rejected, my lords. Then, my lords, I approached this honorable court by filing the WP number 203125 of 2023 before division bench, my lords. And division bench of this honorable court, relying on several judgments, my lords, of the Supreme Court, concluded that, my lords, such an endorsement is not permissible at page number 64, my lords.
No, did it hold the rules are,
How?
rules are?
My lords, rules?
No, did the division bench comment on the applicability of rules?
How, sir? What they did, my lords, that in view of the para 9, my lords, in particular, or relying on all the judgments, therefore, it is very clear that in view of striking down the word unmarried, in Rule 2(1)(a) Roman 1, Rule 2(1)(b) and Rule 3(1)(c) of the Rules 1996, it becomes inoperative and ineffective and thus unenforceable, and therefore it is obliterated from the statute book. In this fact scenario, that
finding is given.
Yes, my lords.
Huh? So that finding is, in effect, it goes away from the statute. So that is retrospective, in effect, that is the finding. So now what has happened?
Now they have issued again same endorsement which earlier they have quoted the reasons. Again, the same endorsement has been issued.
Where
Page
is the
number
endorsement?
70.
Present endorsement.
Page number 70 minutes. 70. Last line.
70?
70 minutes.
Last paragraph.
ಹೌದು. ಮೇಲ್ಕಂಡ ಎಲ್ಲ ಅಂಶಗಳನ್ವಯ ಶ್ರೀ ವೀರನಗೌಡ ಕಿರಿಯ ಆರೋಗ್ಯ ಸಹಾಯಕ ಪ್ರಾಥಮಿಕ ಆರೋಗ್ಯ ಕೇಂದ್ರ ಗಿಲ್ಲೆಸೂಗೂರು ಇವರು ದಿನಾಂಕ 14/2/2019 ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. ನೀವು ಅನುಕಂಪ ಆಧಾರದ ನೇಮಕಾತಿ ಕೋರಿ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿ ದಿನಾಂಕದಂದು ವಿವಾಹವಾಗಿರುತ್ತೀರೆಂದು ಉಪತಹಸೀಲ್ದಾರ್ ಹೋಬಳಿ ಸೋನ್ಸೋ 9/1/2019 ಅಗೇನ್ ಸೇಮ್ ರಿಲೈಡ್ ನೀಡಿರುವ ಮೃತ ಕುಟುಂಬದ ಜೀವಂತ ಸದಸ್ಯರ ಪ್ರಮಾಣ ದೃಢೀಕರಿಸಿರುವುದರಿಂದ ಹಾಗೂ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 21 ಆದೇಶದ ಭವಿಷ್ಯಾವರ್ತಿಯಾಗಿ ಜಾರಿಗೆ ಬಂದಿರುವುದರಿಂದ ಶ್ರೀ ವೀರನಗೌಡ ಇವರು ಮೃತರಾಗಿದ್ದ ಅವಧಿಯಲ್ಲಿ ಚಾಲ್ತಿಯಲ್ಲಿದ್ದ ಕರ್ನಾಟಕ ಸಿವಿಲ್ ಸೇವಾ ಅನುಕಂಪ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ನಿಯಮಗಳು 96 ನಿಯಮ 236 ಅನ್ವಯ ಉಪನಿಯಮ 7 ಅನ್ವಯ ನಿಯಮಾನುಸಾರ ವಿವಾಹಿತ ಮಗಳಿಗೆ ಅನುಕಂಪದ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಾತಿ ನೀಡಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲ.
You are claiming benefit by virtue of the court striking out that charge. Then which is this circular notification they are referring to?
They are referring, my lords, 2021. They have amended by virtue of the judgment rendered by this honorable. They have, my lords.
You have a copy of that judgment?
Bhuneshwari, my lords.
So there was no necessity to amend. But no, what does the judgment say? Let's have. What is the Bhuvaneshwari's case? What is the direction? Is there
May I
a,
read?
was it struck down or there's a direction to amend the rules?
Illa. Struck down means. May I read notes if I allow the writ petition and hold that exclusion of married daughters from the ambit of expression family in Rule 2(1)(a), Roman 1, Rule 2(1)(b), Rule 3(2)(1)(c), which they have relied on. Civil services appointment on compensate ground rules 1996 is illegal and unconstitutional, being violative of Article 14 and 15 of Constitution. I accordingly struck down the word unmarried in rule number so and so of Karnataka so and so. Thereafter, my lords, in consequence, I thereof direct the respondents to consider the case.
So this amendment was not required.
And the Bhuvaneshwari judgment was upheld by the Honorable Apex Court.
We produced those two judgments. Now, if that is so, then in terms of the division bench order, which in effect holds it to be retrospective, you will have to reconsider.
That is, Apex Court, my lord, taken the view, my lord, page number 70, my lord, para number
No,
3.
we have seen that.
Yes.
We have seen
Yes.
that. But we are saying in this case, by virtue of that Bhuvaneshwari judgment and the division bench stating it is retrospective, for which you are a party, you have no other go but to follow Bhuvaneshwari's judgment.
This case is, my lord, state of Madhya Pradesh, and that
No,
is
no, that
another
is-
judgment.
No, that is there. But what we are saying now, by virtue of the explanation of the division bench at para 9, that amendment is retrospective. That's what it says.
That's why, my lord, we are also, my lord, thinking to file review petition or, my lord, SLP against that order. Because, my lord, once it is, my lord, given the compensate, my lord, all the, my lord, will come and seek the same, my lord. That is the reason we will also have it 2 weeks, my lord. We'll get the information whether they are filing the review petition or, my lord. SLP.
Correct. That insofar as that is prospective.
Yes, that is, my lord, the
Your
one of.
Your action is prospective. So this you may have to reconsider the endorsement. I'll have it next week. You take a call, you may have to reconsider the endorsement.
Please.
By
And,
virtue of the division bench order.
Yes.
One more submission is brought. This honorable court, while passing the order, has relied on 3-4 judgments of the division bench of the principal bench,
No, anyhow, that's it.
which held, my lords, that it has to be given the appointment. Irrespective of all this further amendments or, my lords,
Amendment
anything.
is not required. Declaration of court.
Declaration of court.
Relist on 29th.
Please.
You issue fresh endorsement.
Please.
What's it for? Fresh,
No
fresh.
endorsement, you'll have to go ahead with the.
Fresh endorsement. Because I have to 3 times I have approached the.
Correct. Yes. You'll have to go ahead, you'll have to go ahead.
Please.
Yes.
Lord, in this matter, my lord.
Direction was issued to my lord.
Lord, in this matter, my lord, we requested the BEO to submit the report, my lord. As and today, my lord, is not submitted the, my lord, report. Because, my lord, we requested him to submit the report of this institution, whether he is entitled for recognition, approval of the recognition or not. Till today, my lord, BEO is not, my lord, there he is playing, my lord, that is the, my lord, instruction. Lord, you will also have it, finally, you will also have it on 29th, my lord. If he not submitted, but then, my lord, whatever documents is there, my lord, we'll collect it and proceed with the order. There is a procedure, my lord. We have to get the report from the VEO. But in spite of repeated request, my lord, is not submitting the report. Even then, my lord, committee visited to the institution and verified and submitted the report to the BEO. In turn, BEO is not submitting the report to us. That's why finally, my lord, we'll issue letter to him. If he not, then we'll take action against him. If he not submitted the on or before
Correct.
27.
That is your internal affair.
Yes, but that's why I'm not.
But he is the superior.
How is the complainant or the court bothered?
That's true,
by
my lord.
affair?
That's why. Finally, we'll also have it on 29th, my lord. 29th, 29th, my lord, we'll positive order, my lord, will be followed also.
Government advocate request for final accommodation till 29th.
28.
29th.
It stated that the BEO, block education officer, Elli,
BEO
of
the
Muddebihar.
Bihar.
is not cooperating with the superior officers. Such aspect is one between the respondent and his subordinate officers. And the court would not wait till such process of consultation, etc., is completed by the respondent with their subordinate officials. Full stop. It is also made clear that if the BEO attempts to frustrate proceedings pending before this court, necessary action would be initiated against him as well. Copy of the order to be furnished to AGA forthwith.
Please.
This is the matter on 29.
28, my lord.
28.
Please.
30, Arun Kumar Amaragundappa.
Yes.
In this matter, my lord, whatever we notified, my lord, in the notification, my lord, that was thereafter, my lord, it was denotified. Denotified land, my lord, they are seeking payment of the compensation. So that's why I'll file the affidavit of the land acquisition officer, my lord.
What was the direction?
Direction to, my lord, to consider the representation for payment of the compensation of their land, which is submerged in the village tank.
No, now the only point is whether it is submerged or not. Now, if it is not submerged, then you denotify, they can take benefit of it.
That is already denotified.
No, correct.
Please.
If it is submerged, then what is the purpose of denotifying? Unless they can enjoy the property.
That's why, my lord, we have requested the ADLR to make the survey of the entire our tank, whatever it is there, which is the area submerged and which is not submerged. That report is, my lord, not yet issued by us. That's why you will also pay on 30th, my lord. By that time, my lord, if we get
Correct.
the
So
report.
what we are seeing, merely giving an endorsement or denotifying, if it's already submerged, where are they to go? So you get your ADLR report,
Please.
whether it's submerged or not. If it is submerged, then you have to acquire it or pay compensation.
Also make observation also, my lord, we made the request to the ADLR to make the survey and submitted us. But even ADLR is not submitted the report to us. You will also make the observation also.
Government advocate submits that the government has also called upon the ADLR to make a survey and indicate whether the lands of the petty complainant are submerged or not.
That is on 30th/12/2024, my lord, we issue letter to him, my lord. In the update, my lord, I submitted along with memo, my lord, I submitted. Madam.
Page?
Lord, page number, my lord. 5, my lord. 6, my lord. That is dated 30th/12/2024, my lord. Last letter, my lord. ಭೂ ದಾಖಲೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಯಾದಗಿರಿ.
ಏನ್ ಬರ್ತಿದ್ದೀರಿ? Submerged or not? Huh? No, full stop. Communication dated 30/12/2024. Addressed to the Assistant Director of Land Records is produced. Full stop. Land Government Advocate submits that the survey report is necessary in order to make compliance of the order of this court. Full stop. It is also submitted that there has been delay in survey report being received by the Assistant Executive Engineer, Minor Irrigation Subdivision, Yadgir. Full stop. It is made clear that any action of a government official which has the effect of frustrating implementation of court order would be viewed seriously, and such observation would be applicable in this case to the Assistant Director of Land Record as well. Though the said official is not a party, it is made clear that government advocate to communicate today's order to the said official to ensure that compliance of the order is made at the earliest. Copy of the order to be furnished to the government advocate. Release the matter on 30th.
Please.
If it is submerged, you have to.
Please.
If it is not submerged, it's a different matter.
Copy of the order may be given.
Yes, yes.
Please.
Number 40, Mahantesh Patil.
Lord, this matter may kindly be taken after 2-3 days. My lord, I have signed letter is ready on 15th itself, but it was sent yesterday, 21st ಕಳಿಸಿದ್ದಾರೆ. The criminal section ಅವರು late ಮಾಡಿದ್ದಾರೆ. 2-3 days. It may kindly pass over, my lord, up to 2:30. Telephonically, I will ascertain and sub.
Pass over.
Please.
BP Ambekar.
Yes.
Office had raised an objection regarding payment of court fee in this matter. On the last occasion, this honorable court directed the government advocate to take notice. Accordingly, served a copy of the entire appeal memo along with judgment of the trial court with a copy of plaint also on the government advocate on 17th, 1. Therefore, they have to say in the matter.
ಆಯ್ತು court fee, he is saying that we have paid more before the trial court wrongly.
Court fees ಬಗ್ಗೆ calculation ಮಾಡಕ್ಕೆ.
ಹಾ.
So I have written letter
ಹಾ.
2-3 days.
Release the matter. Release the matter on 30th.
Okay.
You find out.
Please, my lord.
Yes.
Judgments, division bench judgments are there.
Correct, let me find. If they concur, there ends the matter.
Please.
Copies of judgment, you give it.
I'll give an add-ons.
60, Udayappa here.
Lord, in this, I may permitted to take hand summons for respondent number 4
The
and may be called on Monday.
petitioners permitted to take out notice by way of hand summons to R4. Release the matter on,
Monday.
yes.
Great.
70, Liaquat Farid Ustad.
Appearing for our. Before this court.
My lord, I'm appearing for the R3 and R4, my lord.
What is the interim order that we have passed?
Lord, the KT order is subject to the result of this writ petition.
So what are the facts now? You
Lord-
appear for?
R3 and R4, my lord. KEA.
I'm appearing for R5 months.
R3 and R4. You appear for
R5 months.
R5.
R5.
Who is this?
R5 months.
Why is she standing? Why is she standing?
Permission. In fact, what happened, my lord, she has, in morning, she has met me and told that I want to argue before the court. I told, no, you cannot. You have to engage a counsel and through him, counsel is there. Therefore, she, that's I was told to her in the morning.
So now, who is the answering respondent now?
Answering respondent is, my lord, respondent number 3 and 4.
Respondent 3 and 4.
Yes, ma'am.
What are your instructions, madam?
My lord, with the, thank you. Just we following the order of government, my lord, and we file the objection within 2 days, my lord.
By Friday, you will file?
Yes, ma'am.
By Friday?
Friday.
We'll have it on Friday.
Yes, please, ma'am.
You have received the paravise?
Yes,
Relist on Friday, let us see.
please.
24th. You file whatever, but you have to file it by 24th.
Please, ma'am.
So and so undertakes to appear for respondent number 5. I wish to show the name of so and so is representing respondent number 5. What are your instructions, counsel?
Yes, ma'am.
What are your instructions?
Lords, she, with the leave of the court, she will submit something.
No, no, no.
Lords,
You
I
have
will
to
get
submit.
instructions on Friday, my lords.
Ah,
I will
correct.
submit.
When you are there,
Yes,
you are her voice.
yes.
Get
We'll get
instructions.
instructions on submit on
Otherwise,
Friday.
we may have to pass an interim order. You better complete your instructions by Friday.
Yes, ma'am.
Yes.
Please.
Number 80.
My lord, office objection may be overruled, my lord, because she has also appeared. Respond number
office?
5, the hand summons was issued to her.
No, no, what is the office objection?
One office objection with regard to typed copy of annexure A1, A2, my lord.
Scrutiny branch office objections.
A1 and A2, typed copy of A1 and A2.
Typed copy of
A1 and A2. We have submitted all the, but A1 and A2 may be kindly dispensed with, my lord, for time being, my lord.
complete copy of annexure H1 to be filed.
H1, my lord, we have filed a relevant copy because this is very bulky.
In light of the explanation of counsel for the petitioner that the relevant portion relied on of annexure H1 has been furnished.
Yes, ma'am.
The said office objection at seal number 4 is overruled.
Yes.
Next. Advocate for petitioner to clarify why petitioner is made party to the you have
Yes, ma'am.
filed IA to challenge that order. Isn't it?
Yes, ma'am. No, we have filed that order. We are challenging the KT order since we were not made as party.
Correct. You have sought permission, isn't it? Have you filed an IA seeking permission to challenge that order?
No, no, I have not filed. I will file.
You have to file.
I will file.
By Friday, you have to file.
I
submission, my lord.
And just 1 minute.
I will file it.
Counsel for the petitioner, because we couldn't have
Yes.
issued notice unless you seek leave of the court.
Yes.
You file it immediately.
Immediately I will file.
We'll pass over, you file that, let it be on record.
Please.
Then next is legible copy of A, A2, A3, A9, A13, A18.
All are KT annexures, my lord, and whatever.
Lord counsel, insofar as office objection is seal number 6, counsel for the petitioner submits that if the said documents are relied upon
Right.
at the time of hearing, legible copies would be furnished.
Yes.
Subject to such undertaking, office objection seal number 6 is overruled. 5, you file it, I'll pass.
Yes.
over.
But your lordships, my lord, I came to know about through my colleague, fix the date on Friday, my lord. It could not be possible filing of the objections, get the affidavit from the Bangalore, my director, my lord. Matter is, my lord, neither his selection is not sustainable or his selection is not sustainable. What happened, madam? The purely post was post called for the Urdu medium purpose, my lord. Normally in Urdu medium, my lord, the people who are complete to be people are already maybe they will learn the Urdu and they are eligible for the selection, my lord. In this matter, happened, my lord, as per the roster of the selection list, we have reserved the post for SC/ST category people's, my lord. Non-available of the candidate from SC/ST on that category, we have obtained the permission from the government. These selections proceedings for in non-available of the persons and under the category of SC/ST for the Urdu medium, it may be permitted to us. It is converted into a general merit. After giving up the after obtaining the permission, the general merit, they both are selected. She was challenged the before the KAT. BFE, KAT, the Honorable KAT has passed the impugned order that no, it should not be not sustainable in law. The SC/ST reservation roster should not be converted in a GM. So, this order made. So, due to the impugned order, if we are sticking on that impugned order, neither his petition is maintainable or she is not maintainable. Both are as goes.
Okay, you file, take it in writing.
The time may be granted to 1 week and a back at least.
When do you?
It may be on 30th or 31st. 31st?
30th.
Not 30th. Please, I will file the detailed objections.
This on 30th.
Please.
Not what my learned friend is submitting, my lord. New appointment, new eligible.
There is some government order, I think, that is impermissible to de-reserve SC.
That's why I will file the detailed objections for that.
Let us.
Please.
Yes, next.
Number 80, Veeranagowda Malipati.
Preparing for offer.
Interim order may be continued. Sorry for this.
What is the interim order? No interim order. Okay.
The order of the
No, correct. That's
Subject
what
to-
we have already stated will remain.
case.
Filed IFR recalling one.
1,600 days.
Claimant's appeal, my lord, seeking enhanced. The respondent.
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಅಟ್ಲೀಸ್ಟ್ ಕೇಸ್ ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕಲ್ಲ 4 ವರ್ಷ ಆಯ್ತು. Why was it dismissed? Where is the order?
For non-compliance of officer.
Where is the order?
Second.
Order dated?
Order dated, my lord.
Now you have complied with all officer.
All officers. I have complied. 18/7/2016.
We'll allow it on cost. 1 ವರ್ಷಕ್ಕೆ 1,000. 3 ವರ್ಷ ಆಗಿದೆ ರಫ್ಲಿ 3,000.
Lord, on submission, my.
ಬಂದಿದೆ.
One submission by Lord.
ಹ್ಮ್.
Apart from caste, the claimants are not entitled for the interest for this.
Yes,
relief.
yes. IA 1 of 21. Has been filed seeking for recalling of order dated 18/7/2016, by virtue of which the appeal came to be dismissed by a statutory order. Taking note that by an order, taking note that office objections were not complied. Such order was passed on 18th July 2016. IA, another application has been filed seeking condonation of delay in filing application for recalling the order of dismissal. During the pendency of the proceedings, appellant was permitted. This condonation in appeal. During the pendency of the said application, the appellant has complied with the office objection. Taking note that the appeal has been filed by the claimant. And it is a case of injury na death.
Death and one injury. 2 cases, sir. This death case.
And taking note that the claimant is a legal representative of the deceased who died in the motor vehicles accident. By taking a liberal view, delay is condoned, accepting cause shown in the affidavit filed in support of the application, as well as the oral explanation made. The application is allowed subject to payment of cost of rupees 3,000 to the High Court Legal Services Committee. Needless to state that the restoration of the appeal by virtue of setting aside, recalling the order of dismissal would result in the restoration of appeal and time spent from date of dismissal till date when order is passed for restoration of appeal would not entitle running of interest during such time. In the event, the compensation is enhanced. You are ready? Ready?
Ready.
Huh?
Ready.
What is the case?
What vehicles are involved in this case? There's one is Travera Jeep. And another is lorry mill. Lorry mill. The deceased was traveling in the Jeep, my lord. Correct. He was traveling in the Jeep. My lord, the charge sheet has been filed by the concerned police after investigation that the driver of the lorry does not hold DL at the material time of accident. And also, owner is also prosecuted that he has been entrusted the said lorry to a person who does not have any DL.
No, who is negligent in terms of the charge sheet?
My lord, as per the respondent number 1, here in this case, my lord, the owner of the trial court, owner of the Travera Jeep, 2 is the appellant, United India Insurance Company Limited, 3 is the owner of the lorry.
Charge sheet says who is at fault?
Lorries.
Lorry. No, not for entrustment of vehicle.
Yeah. Charge sheet has been filed against the lorry driver. May I read, my lord?
Oh, that's okay. Then?
And not only charge sheet against the lorry driver, plus also owner has been prosecuted. Both.
Correct.
Now, the tribunal, while considering the evidence on record, has come to the conclusion that both are negligent. Driver of the Jeep and also lorry driver. And granted the compensation without apportionment, because the tribunal has positively come to the conclusion that the alleged accident has been occurred due to the rash and negligent act on the part of the both drivers of the vehicle. Now, when such is circumstances, there should have been apportionment. That apportionment has not been done. Now, while passing the award, may I read, my lord, the last sentence of the judgment, my lord? The respondents number 1 to 3 are jointly and severally liable for payment of the compensation. So 1 to 3 means 3 is the owner of the lorry mill. Here in the entire judgment.
No, who is the insurer of the other vehicle?
That he is not that lorry is not insured.
Not insured.
Insured. Only owner has been made as a party to the proceedings.
He served. Owner is served.
Sir.
Shivasharan, son of Revanna, Siddhappa. Owner of the lorry mill. This lorry probably might not have been insured. So therefore, they are not made a party to the proceedings. Lorry owner. R3, owner of the lorry. R2. Insurance of the Travera Jeep. Lorry insurance.
So
lorry is not insured, my lord. Lorry is not insured.
Correct. Where is the finding regarding?
Regarding finding, my lord, I would like to bring the para 5 of the judgment, my lord. Para 5 of the judgment. No, just reasoning, my lord. Reasoning. May I read the relevant para, my lord?
No, you can proceed. You can go against any one of them.
Yes.
Claimants,
law.
that is the reason,
is
my
the
lord.
authorization.
That is the reason, my submission, my lord, before this honorable court, to go ahead against the other person, here apportionment, entire life pay and recover against the owner. And also this Tribunal jeep driver is also not holding license. I will also let an evidence.
No, correct.
Yes.
Now, you can go against any one joint, one of the tortfeasors.
Yes, sir.
That will observe your right to proceed against the other tortfeasor will protect you. You are the insurer of the Tavera Jeep.
Tribunal jeep.
Your, that has a insurance.
That is insurance, my lord.
Right? So we are saying that you can pay, not only recover from your, insofar as your liability.
Yes, ma'am.
But also seek for defraying of your extent of liability by against the other short fees.
Yes.
That is the law.
My lord,
So now insofar as what is the 50% each, what is it?
50%.
50% ಮಾಡಬಹುದು because the lorry is a bigger one. For me, Tribunal jeep, it may be done as a 40-60 my lord.
No, but what is the evidence?
Sketch.
Evidence is not there. So 50-50 ಮಾಡೋದು. There is no conclusive evidence. ಇವ್ರದೇ ಇಷ್ಟು ಅಂತಲ್ಲ. Both way head on collision ಅಂತಕೊಂಡಿದೆ. I leave to the honorable court.
In connected matter, my lord, in the injury case, my lord, they have fixed liability on 50% each on two
Fixed.
vehicles. Oh,
ಯಾವ್ದ್ರಲ್ಲಿ?
connected, my lord. My lord, 201126, my lord.
201126. Their liability is 50-50.
50-50. Page number 15 of the judgment.
Same judgment. Judgment. Same judgment, same.
15, page number 15 of the judgment, last
Page?
15, my lord. In page 20.
Different tribunals pass.
Yes.
Even though.
So I am the opinion, my lord.
Cannot be
Last 7th line, my lord.
Mr. Aspelli,
Yes, my lord.
cannot be depending on the size of the vehicle.
That's why I'm
Driver is
Small.
I consider my lord, but still, just I would like to bring my lord's notice, my lord.
page number
Paragraph?
15, my lord, para number, unnumbered para. Last 7th line, man. So I am of the opinion that there is a negligence 50% each on the part of the respondents 1 and 3 drivers.
You appear for the claimant.
Claimant.
Now on, only on liability you have filed or on enhancement?
Enhancement.
On what ground you are seeking enhancement?
My lord,
You take one by one.
in the case of death, my lord,
Ah.
deceased was a student of Bachelor of Engineering,
Hmm.
4th sem, my lord. That
Fourth sem.
income has taken 6,000 rupees per month, my lord. And bachelor death, my lord, age of the mother is taken, my lord, instead of deceased age multiplier.
It may be reassessed, ma'am. ಅದರಲ್ಲಿ 50% future prospectus consider ಮಾಡಿದ್ದಾರೆ. Not in, that is one of my ground. If it is reassessed.
No, correct. So now you tell us.
8 to 20. Bench, my lord, may I request, my lord, 25/11/2024 order.
This stays.
The stay was not granted.
Ah.
During the pendency, my lord, now, my lord, they have issued appointing the election officer to conduct the elections and redo the entire.
Calendar of event also is announced.
Not announced. Not announced. Only election officer was, my lord, appointed on 4/12/2024. May I request, my lord, 25/11/2024, there was an order by this honorable court.
On order dated
25/11/2024. I have relied on the one judgment of the apex court, my lord, reported in year 2001.
correct, but now what is the direction? The direction is only to redo the whole process.
Yes, my lords. In fact, if 2 or 3 days awaited, my lord, I would have been declared as unopposed, my lords. These
Correct.
appellates.
Before that only all this has happened.
Yes,
So how are you aggrieved now?
but I am the candidate, my lord, who has to be declared as unopposed.
No, at that point of time, still results were not yet announced.
Lords, if, my lord, on 25th is
They
the
sought
last.
for correcting of the voters list
Yes.
when the election process was on,
Oh, yes,
isn't it?
yes.
So election process still had not concluded. Now
It-
they say revise the voters list and hold election. There ends the matter.
Our contention is, my lord, the writ petition itself is not maintainable. May I request the judgment of the apex court, my lord? Para 12, my lord. If at all, my lord, there is a discrepancy or not following the rules, my lord, 12 or 13 or 14 of the, my lord, Karnataka cooperative rules, the court cannot, my lord, entertain the writ petition, and there is alternative remedy for the, my lord, petitioners before the learned single judge under 70 subclass 2C, my lord. One para, short para, my lord, may I read, my lord, judgment of the, my lords. I have given the judgment. Court of the judgment is Supreme Court is finally.
But Ashok Kumar's case, Ashok Kumar's case says you can correct the discrepancies in the process.
This, there is
Ashok Kumar.
another Leonard single judge order, my lords, with permission, wherein Ashok Kumar case also considered and held at, my lords, the preparation of voter list is a integral part of election and always subject matter of section 70 minutes. Only in an exceptional case where, my lords, court find that there is a.
No, correct. Ashok Kumar's case deals with that.
Lords, the
It
Ashok
says
Kumar case
if
also.
there is a defect,
Please.
it can be corrected. That's what
At
the
the- at
Supreme
the-
Court has said.
Ashok Kumar case also considered by the Leonard single judge with permission, my lords.
Not single judge. I have a different take on that. I have also as a single judge held in case of municipal corporation.
Yes,
election,
yes,
2019.
That reservation roster,
Roster.
that writ petition is maintainable, isn't it?
Let's in reservation matter, my lords, kindly
Correct.
appreciate.
Here now.
Let's in
there's
the
a defect-
panchayat.
There's a defect in the voters.
Please.
So their contention of the petitioner, you are the petitioner,
He is a
is
petitioner.
that there must be a rectification and the election process be concluded.
They are
So the
disqualified.
court, then intervenes and says you revise the voters list and do the election, whether that is permissible or not. 1995, is it Ashok Kumar?
Ashok Kumar.
Put it, it is. I'll have it tomorrow, you read Ashok
Please,
Kumar.
please, please.
I've interpreted it in that reservation roster.
Some cases, let's kindly appreciate under the Karnataka Panchayat Raj Act, section 19 contemplates in regard to in what are all grounds, my lord, the election petition can be filed. Lords, in the grounds it is not available. One of the ground is not available as regards to reservation is concerned, my lords. Therefore, my lords, your lordship held it's maintainable. In the instant case, my lords, the section 70 covers the entire election. Lords, the voter list, preparation of voter list is an integral part of a election process. Therefore, my lords, this honorable court held that, my lords, it's always a subject matter of section 70 dispute, mean election dispute, my lords. And Supreme Court, my lord,
Right, but
and
now at
always,
this-
my
now
lords,
at
as
this stage, now look at already how many, 4-5
Six-
months have passed.
6 months.
it's the
6 months have passed.
Already the procedure which the
It's-
court has directed to follow the procedure,
Hmm.
that would have been completed, my lords, if the procedure was
Now, who has to revise that?
the election officer and the election commission.
Now you find out what has happened.
let's,
But we
May I
issued notice to the appointing the election officer, my lord. Further proceedings, my lord, we have to proceed.
No, no, correct.
Because of
Revision of voters list is to be done by whom?
By the
done by the election officer, my lords, under Rule 13D, election officer has to redo it, my lords, with the assistance of a CEO of a concerned society. If at all, my lord, redo madidru, they are not eligible for the voters.
Yaru?
The private respondents, my lords. As a
again, they
petitioner before the
has to
learned
be
single judge.
declared, my lords.
Section Yeah. 20,
The eligibility of voter list, but with respect to the following the procedure rule 13D, after my lords, the CEO, once he prepared the list, draft list, my lords, voters list, he has to refer to the election officer. Then election officer has to issue notice to all the members, my lords, through the RPAD, asking them to file a reply. Thereafter, all the proceedings has to be completed and final voters list has to be published. Entire procedure is in violation. They have brought out of 3,265, 120 voters were made eligible.
no, 141 voters.
141, when irrespective of that,
Out of 3,000.
3,265. And all our ballots now they have made out of 80% voters are belongs to the city and the cooperative society. The whole purpose of cooperative society, the object of cooperative society is to include all the villagers.
Anyhow, this is going to take time,
Please,
even if they have to prepare. So we'll have it next week. You come ready.
Please.
One on maintainability.
please.
So you see my interpretation in Ashok Kumar's case. We'll see. Have a
Yes, my lord, we have read that. Ashok
look
Kumar.
at it. We'll have it next week. And you also take your stand.
In the
Make it
meantime, my lord, para 12 of my lord's apex court judgment, my lords, I have
Huh?
12. my lord.
good.
This issue is covered, my lord. ಎರಡನೇ, even there is no compliance, my lords, the apex court held it. It could be a subject matter of a dispute.
Yes, read.
Notes para 12. my lord. In view of our finding that preparation of electoral roll is being an intermediate stage in the process of election of managing committee of a specified society and the election process having been set in motion, it is well settled that the High Court should not stay the continuation of election process, even though there may be some alleged illegality or a breach of rules while preparing the electoral roll. It is not disputed that the election in question has already been held and the result thereof has been stayed by an order of this court. And once the result is of the election is declared, it would be open for the appellant to challenge the election of returned candidate if aggrieved by means of election petition before the election tribunal.
Okay, you get ready. But here is the case where election were already held.
Already held.
Result was stayed.
That is why
No, correct. But now on maintainability, if you have to make out your case, whether the court can intervene at this stage. Their contention, it cannot be done. That you make out your case.
Oh, bless.
Release the matter. Next week, date good. Huh? 30th.
Oh, bless. In the meantime, my lord, government advocate may be direct not to precipitate. on
No, no, nothing will
I'll-
happen. At least for next election, at least let the voters list be done.
let's say, as regards the preparation of voter list, always, my lords, the subject to section 20. Section 20 contemplates, my lords, who does not do a business consequently 3 years
Correct.
and who does not attend the 3 meetings. There are other disqualifications.
Yes.
Lords. The preparation of voter list always subject to section 20. In the instant case, my lords, more than 3,000 voters, they did not come forward to attend the meeting, my lords. Even if the election officer redo it, my lords, they again, they disqualify to contest or vote this thing, my lords. The end result is, my lords, they are not eligible.
One submission is, not sir, what is happening in following the procedure 13D in all the cooperative matters. The procedure contemplated, my lords, which mandatorily requires issuance of notice. And subsequently, all the cooperative societies, my lord, they have not issued, even in the present case, one of the 2 members, my lords, have filed an objection stating that we never received any notice for meeting.
Correct. This argument I'm hearing since I became a judge in 2018.
It's as rates.
No, no.
The-
Every year, every election, same problem. There's no improvement at all. Government must ensure
that is why.
Now, my lords, now
the rule says
Yes, my
that
lords.
before election, what is the procedure? How, within how many months before this must be
6
done?
months.
But continuing deep.
Records, my lord. We issued the notice, but not RPD by ordinary post, my lord. They served also. They never represented, not filed any reacted that one. And societies, my lord, we have to send the notice to RPD, my lord. Society don't have the budget to send that amount. That is the problem, my lord. That is
Let us
the.
see.
It's a voluntary act, my lords.
You just place that single judge's order also.
Please, my lord.
What is the view taken by the single judge?
Single judge says, my lords, the this preparation of electoral rule complete disregard to order rule 13D subsection 2 capital A, my lords, which contemplates, my lords, the society has to issue a notice to all the defaulters as well not attending meetings. The first instance,
If there is such lapse, then what is the remedy?
my lords, he has to issue a notice. Lords, in the meantime, my lords, the voters should file their objection.
So if
All
this-
the lists should send to the election officer
Correct.
to decide.
Has to be sent to the
Election officer
Election
to decide the consideration of objection, my lords.
To declare it, my lords, eligibility.
the process has started. Before the
Before 6 months, my lord.
Before 6
15 days, notice has to be issued 15 days prior to the 6 months of the election.
6 months.
And that procedure has not been complied.
on maintainability you address. Which is, but you said the single judge said it's not maintainable.
Allah, that is wherein, my lords, in exceptional cases, this court can entertain, but in regard to the, my lords, there are some irregularities which can be cured and which is covered under section 70,
It's
then
single,
it has to be approached to the election tribunal. ಇದರಲ್ಲಿ 3,100 were declared, my lords.
Let us see.
they did not attend the meeting, my lords.
They were never, my lords, issued the notice for attending the meeting, nor they have conducted any
No,
meeting.
no.
Correct.
Rule 14J contemplates, my lords, at the time of AGM, the society will not issue notice. They only issue a publication in the newspaper, my lords. It's practically impossible to issue a notice and get them to attend the meeting. Rule 14J says, my lords, it's only a publication, news publication.
You have to point out now that even if there's a revision, you will be considered, or at least some members may come within the voters list.
Huh.
If
How
none of
many
you are going to come, then what is the whole purpose of the exercise? We'll see.
Oh, bless.
Yes.
Number 20, Ravi V. Patil.
This matter, my lord, appear for 1 to 3, my lord. IFR, my lord, CD may be considered, my lord, and post this matter, my lord, second week of
The one
February
of
for hearing.
2024 is allowed.
Santosh R. Belamgi, my lord,
Accepting cost shown in the affidavit. Affidavit
please.
filed in support of the application.
My lord, I was directed to serve Santosh R. Belamgi, my lord, who had appeared for, my lord, the respondent, who is also served in the present matter, my lord. He said, my lord, he is having no instructions
No
to appear on behalf of.
So it has to go to R4-1A.
R4 is already served, my lord. Through the process of the court itself, he has been served.
Served.
Yeah.
So we have to only show the name of R4-1A.
Yes.
As served in the cause list.
Please.
Check ಮಾಡಿ ಅದು R4-1A serve ಆಗಿದೆ. Learned counsel for the appellant submits that copies of the writ appeal were served on learned counsel Santosh R. Belmagi, who had appeared on behalf of R4-1A in the writ proceedings.
Yes.
However, the said counsel is had stated that he has no instructions to appear in the matter. Accordingly, office to delete the name of third counsel so and so as shown as representing R41 capital A. It is noticed that court notice has been served on the said respondent. However, the said respondent has not put in appearance. Accordingly, office to show the name of R41A as served in the cause list. List the matter.
11th or 12th one.
Put it.
11th of February.
Please. Yes.
Number 21.
Kindly post along with these matters, my lords. Total 6 matters, my lords, 3 filed by the insurance company and 3 filed by claimants.
List along with the
Um,
date code. Huh? So who accepts notice then?
Otherly, insurance company is also filed, my lords, 3 appeals filed by Mr.
He only appears in those matters.
Out.
So and so, this really.
Manjunath Malaya
Shetty.
Also.
Manjunath Malaya Shetty, directed to take notice for respond number
2, my lords.
2. Issue notice ಆಗಬೇಕು ಉಳಿದವರಿಗೆ ಬೇಕಾ?
ಇಲ್ಲ R1 in my case, my
R1
lords,
ಗೆ ಮೆಮೊ ಹಾಕ್ತೀರಾ?
ಹಾಕ್ತೀನಿ sir.
Huh?
ಹಾಕ್ತೀನಿ.
Yes, then counsel for the appellate, so it's a memo to dispense the notice for respond number 1. Placing
ಅಲ್ಲ
reliance on
respond
memo,
number
placing reliance memo, comma, notice
3,
to R1.
3 is also there, my lords, 3 and 4.
ಎಲ್ಲಿದೆ
4 is my
3?
lords, Oriental Insurance Company.
1 and 2 only, ಎಲ್ಲಿದೆ?
ಇಲ್ಲ ಅದರಲ್ಲಿ my lords office objection raise ಆಗಿಲ್ಲ. There is a respond number 3 and 4 is also there, my lords.
So you filed.
I make my lords correction, my lords. Respond number 3, 4 name not shown.
The land council is permitted to amend the cost item by in pleading.
3 and 4 ಅದು ಆಗಿಲ್ಲ ಸಮಯ by oversight, my lords.
3 and 4. Aye. ಈಗ issue ಅದು ಹಾಕಿ so and so.
Respond number 1 and 3 may be dispensed with, my lords, and R2 is my lords Manjunath Malaya Shetty, and R4 is my lords
1 and 3 dispensed by placing and placing reliance memo filed by the.
yes, my lords.
land
And
council for
R4
the
my
appellate.
lords. R4
R4.
Oriental. Liability.
3.
R4 Manavendra Reddy.
Shri Manavendra Reddy is SF to take, SF notice to respond number 4.
4.
Records ಬಂದಿದೆ ಅದರಲ್ಲಿ.
ಅದರಲ್ಲಿ ಗೊತ್ತಿಲ್ಲ ಸಮಯ post along with.
ಇದು is directed to secure the PCR. Telephonic. Tag this appeal along with the appeal. List. Re-notify on your date. February. What year is that? February. Yes.
Much.
Right. List all these appeals.
Number 23, BK Hiremat.
Yes.
Prayer has been included, my lord.
Huh?
Last.
No, correct. So on merits, what are the grounds you have raised? What are the grounds you have raised?
Grounds is only that, my lord, he has involved in 8 cases, sir. As per their 8 cases, they responded number 2 and 3 was registered a Gunda Act, ma'am. And out of 8 cases, totally 5 cases were acquitted, madam.
5 cases?
Were acquitted.
No, but page 85 alli, only 3 cases acquitted, another.
I have produced judgment, madam. Annex, sir, 8 to E are the judgments of the, madam.
Annexure A to
E are the judgments of trial court, madam.
Annexure A is which item in page 85?
Yes, my lord.
One of 2017.
Yes.
Now anyhow, at page 85, 1 to 3, they've said acquitted.
But
4, 5, 6,
7, 8.
7 and 8. Adutors.
But actually they have not taken proper, correct, my lord. I produced the judgments of the trial court, my lord. Totally 8 cases were filed against the petitioner, my lord.
Correct. So now you point
And
out
as
what has
per
happened to 61 of 2020. Tikota.
Tikota is pending, my lord. It is pending.
Next.
And 8 is pending, my lord. 4, 6 and 8 are pending, my lord. And 6 and 8 are, it is at the stage of statement record, 313 statement, my lord. But only remaining one case, that is Tikota PS crime number 61 of 2020, my lord. In that case, they have taken section atrocity case, my lord. So this atrocity case is not applicable to present petitioner, my lord. Other offenses is liable. ಇದು ಇತ್ತು 2325 ಕನ್ವರ್ಟ್ ಮಾಡ್ಕೊಂಡು ಇಲ್ಲ ಕನ್ವರ್ಟ್ ಮಾಡಿ ಆಗ್ತದೆ.
So what are the now what are your grounds now insofar the criminal case? That's one. What do you say? Public order.
He has not made any public peace or public tranquility, man. Only the respondents telling that he is involved in criminal cases. On that ground, they have filed pass an order under detention, man.
Mr. Government, what is the nature of offenses crime he has committed? Nature of crime, ಏನೇನ್ ಮಾಡಿದ್ದಾರೆ?
ಇಲ್ಲ, I'm sorry, my lord, to say, WPSC ಅಂತ ಆದ್ಮೇಲೆ ಫೈಲ್ ಇಲ್ಲ. WP to convert ಆಗಿ.
Last time, Mallikarjun Basadi very well known.
Same file. Get ready.
Date has been given.
We'll have it on Monday.
Please.
In that already statement is filed in the previous process.
The nature of offenses, what is the involvements and acquittal, I will go through and submit.
Yes. Statement is already on record.
Recorded.
We list on Monday.
Mahesh Patil.
No, appearing for the petitioner in this case.
Now,
Yes, ma'am.
if we were to accept your contention
Yes, ma'am.
and order of further inquiry set aside,
Yes, ma'am.
let's assume that the order of further inquiry is set aside.
Yes, ma'am.
Then it will go back to the stage
Yes, ma'am.
where the inquiry report is, original inquiry report
Yes.
is to be placed before the government.
Yes,
That is the disciplinary authority.
Yes, ma'am.
Then they will take a call in accordance with law.
Yes,
Now
ma'am.
you-
Let them take they have to go with the records, materials,
Yes.
then let them take a decision
Yes.
according to the judgment I have produced.
Yes, yes.
Yes,
Good.
please.
Now, that further inquiry, they say you can go to 11. If you go back to 11, that means you can frame charge, etc.
Under 11(1) ಅಂತ ಇದೆ ಸ್ವಾಮಿ.
ಹಾ,
not
ಕೊಡಿ.
under 11(2).
Correct.
11(a)(2). It is 11(a)(1). It is.
11(1), 11(a)(1), 2, 3. I have extracted in my pleadings itself.
No, just
In
one.
addition to the additional,
ಕೊಡಿ.
the further inquiry ಅಂತ ಇದೆ. Fresh
Correct.
inquiry ಅಂದ್ರೆ ಮೊದಲಿನ ರಿಪೋರ್ಟ್ ಹೋಗುತ್ತೆ ಸ್ವಾಮಿ.
No, correct. Now, two things. Now, if you were a Supreme Court judgment, they SEC. Now, there are two things. It should be strictly speaking further inquiry.
Yes, ma'am.
So further inquiry means there some witness has not been examined because he was not present, or some such matter where already inquiry has not touched that aspect. So here, Upalokayukta has commented on the findings. You look at the extraction of the Upalokayukta's opinion that we find at in that annexure A8. Now you just look at what the Upalokayukta has observed.
May I read, madam?
That
Page number 93.
correct.
ಪ್ರಸ್ತಾವನೆ.
No, you go directly to
94.
observations of the Upalokayukta at page 94.
94 ಮೇಲಿನ ಅಂಶಗಳನ್ನು.
No, in the course of reply.
My lord, in the course of reply dated so and so, the DGO has not mentioned anything as to why the evidence of investigating officer by name so and so, who is examined as PW cannot be believed. The DGO has not whispered anything in the course of his reply that he has obtained permission of his competent authority to lend loan to the complainant. Evidence of PW4 would show that DGO has found in possession of the tainted currency notes of rupees 12,000, which is supported by the change of color of finger wash of DGO. It seems that the inquiry officer has not properly appreciated the said aspect. It also seems that the inquiry officer has equally not properly appreciated the fact that DGO failed to offer satisfactory explanation before PW4 touching possession of tainted notes. The reply dated so and so, DGO against the Shoka's notice is not worthy of acceptance and therefore the same cannot be accepted.
Now this relates to an appreciation
Yes.
that you can't reappreciate in further inquiry. Now, the scope of further inquiry by Constitution Bench judgment of the Apex Court says on what circumstance you can do a further inquiry. It seems to us that under Rule 15, on the face of it, really provides for one inquiry, but it may be possible if in a particular case, there has been no proper inquiry because of some serious defect has crept into the inquiry. Some important witness were not available at the time of inquiry or were not examined. For some other reason, disciplinary authority may ask the inquiry officer to record further evidence. But there is no provision in rule so and so for completely setting aside previous inquiries on the ground that the report of the inquiring officer or officers does not appeal to the disciplinary authority. Now, the
Evidence
decision
and-
must be taken by the disciplinary authorities. Here, Upalokayukta has stated something which these people have accepted. On the basis of the same evidence, disciplinary authority may come to a different decision. That power is still available.
Please.
So we leave it at that.
The only annexure A8, my lord, will be cautioned. The report will remain and it will be.
Yes,
placed.
yes.
Please,
That we are not disturbing that.
please.
The final one word it says. The present petition has been filed by the applicant before the tribunal, who has called in question the order of the tribunal at page
93 of impugned.
Lord, 129,
order of the tribunal
Annexure C.
in application number 20563 of 2020, wherein the challenge by the employee as regards to the order at annexure A8, which is an order by the disciplinary authority directing further inquiry, has been rejected. The brief facts are that the petitioner was working as an assistant executive engineer, PWD subdivision, Balki, and complaint was lodged before the Lokayukta, Karnataka Lokayukta Police on 10/11/2011, alleging that petitioner had demanded a sum of rupees 12,000 to recommend his name to the executive engineer for award of contract. It's further made out that a trap was conducted and there was entrustment in terms of section 12(3) of the Karnataka Lokayukta Act. Next, inquiry was held by the Upalokayukta through an inquiry officer, that is additional register of inquiries to 11, no?
11. Enquiry is 11.
Full stop. It is also admitted that the inquiry report had held the charges to be not proved. Subsequently, it appears that the Upalokayukta had recommended that there needs to be a further inquiry and reinvestigation. And on the basis of such recommendation, the order at annexure A8 challenge before the tribunal came to be passed. In terms of annexure A8, the disciplinary authority, accepting the recommendation of the Upalokayukta, had remitted the matter for further inquiry. The tribunal has considered in detail the contentions of the applicant petitioner and rejected the application. It is the finding of the tribunal that there was power to order further inquiry.
In para 10 of the KAT order.
The tribunal has observed there was no infirmity in the order remitting the matter for further inquiry. And as noticed, power conferred under 11 capital A of the Karnataka Civil Services Rules 1957. And in specific 11A
1
bracket 1, which provides for holding of further inquiry. Lord Counsel for the petitioner has raised various contentions, including that in the guise of further inquiry, there could not be a de novo inquiry resorted to. It's further submitted that the disciplinary authority under 11 capital A is required to take a decision to hold further inquiry, and such decision must be taken by the disciplinary authority, whereas in the present case, such decision has been taken on the mere recommendation of the Upalokayukta, and accordingly, decision taken cannot be stated to be a decision taken with application of mind. Next, it's further submitted that the extraction of the observations of the Upalokayukta in the order at Annexure A8 would indicate that the Upalokayukta was of the opinion that the appreciation of evidence and conclusion arrived at by the inquiring authority was not proper, and such appreciation would be impermissible in a further inquiry. He submitted that a further inquiry would be ordered only in case of any lacuna of non-leading of evidence of a vital witness, etc., and cannot be ordered where the authorities concerned are not in agreement with the conclusion of the inquiring authority. And counsel appearing for the state would submit that the order at Annexure A8 only provides for further inquiry, and such further inquiry is contemplated under 11 capital A1 of the KCSR rules, and the tribunal has rightly permitted going ahead with such further inquiry. It is also submitted that there is the petitioner would not be prejudiced by further inquiry, and the contention of the petitioner that there was a direction for de novo inquiry cannot be gathered from the plain wordings of Annexure A8. Accordingly, it is submitted that there is no case made out on behalf of the petitioner. Next, peruse the order of the tribunal. Next, it is to be noticed that the only question that falls for consideration is as to the legality of Annexure A8 in ordering for further inquiry. A close perusal of Annexure A8 would reveal that the report of the inquiry officer has been placed before the Upalokayukta. Subsequently, before forwarding the file to the report to the disciplinary authority, Upalokayukta has made certain observations found at page 2 of the of Annexure A8. The said observations are extracted here under page 94 English. Next. No doubt it is clear that the disciplinary authority has directed for further inquiry in terms of Annexure A8. However, the question to be noticed is as to whether the direction of further inquiry is to be sustainable. 11A1 of the KCSR rules reads as follows. The
11A1 and 2, 3. 2 and 3.
No, but further inquiry is under 1.
Yes, my lord. If it is, my lord, that the disciplinary authority shall disagrees with the findings, my lord, that the inquiry authority may be article of charges record the reasons anta ide 11A2 then. They have to that I have extracted in page 8.
That will come.
That-
11A1, just wait, I'll finish then you.
Yes, sorry, my lord, please.
11A1 reads as follows. It is clear that the decision for further inquiry is to be taken by the disciplinary authority if it is not the inquiring authority for reasons to be recorded in writing, and would remit the case to the inquiring authority for further inquiry and report. In the present case, it is to be seen that the disciplinary authority, though exercising power under 11 capital A1, has merely taken note of the observations of the Upalokayukta, who has opined that there ought to have been further inquiry. Full stop. There should be an independent application of mind by the disciplinary authority who is to come to a conclusion after recording reasons. Full stop. This would make it clear that before ordering for further inquiry, reasons must be recorded. Full stop. Merely adopting the opinion of the Upalokayukta would not amount to application of mind. Full stop. Next. It must be seen that while ordering further inquiry, it is necessary that the aspect of further inquiry has to be delineated and specified in the order of further inquiry itself. The scope of further inquiry is not forthcoming on a reading of Annexure A8. The apex court in the case of the apex court in a judgment of a constitution bench in the case of K.R. Deb versus Collector of Excise, Shillong, 1971, volume 2, SCC, page 102, at paragraph 12, has made certain observation as to the scope of further inquiry. The observations in para 12 are extracted below. Next, it is clear that the further inquiry contemplated is in so far a certain defect or shortcoming in the inquiry. Yeah, in the present case, the Upalokayukta's observation relate to appreciation of evidence and conclusion reached by the inquiry authority. In the guise of further inquiry, there cannot be a direction to the inquiry authority to come to a different conclusion on the basis of the same material. The word inquiry refers to evidence to be let in. There is no indication of what further evidence was to be let in on further inquiry. In light of the same, the order passed is ambiguous and does not make out a case for further inquiry. Taking note that the report of the has already been placed before the disciplinary authority. Needless to state, consequent to setting aside of A8, disciplinary authority is permitted to take further steps in accordance with law as per procedure stipulated.
On the report, inquiry.
Yes, anything else, madam?
My lord, that subsequent criminal case is acquitted, that may be considered, my lord, while passing that order. And according to that report may be considered. That is what, that's it.
No, now, the second notice will be issued to you, isn't it?
Yes, my lord, yes, my lord.
You can raise it.
ಅಲ್ಲ
Needless to
ಅದರಲ್ಲಿ
say,
ಸೆಕೆಂಡ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಈಗ ರೀಸೆಂಟ್ ಆಗಿ ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಆಗಿರೋ.
no, now disciplinary authority is to again take a decision on the inquiry report.
Yes, ma'am.
If they accept it, no notice to you. If they are not going to accept it and going to come to a different conclusion, they'll give you a notice, then you can raise it.
Yes, ma'am.
Now
Please.
they may accept it. Then
Please.
there ends the matter. If they don't accept, they'll give you notice, then you can raise whatever.
ಅಲ್ಲ, if possible, my lord, that may be mentioned because he is retired, my lord, and bedridden. Why he is simply, suppose it is come to the order, my lord, then it will be good
No,
for him.
If we were to observe that the disciplinary authority is to give you notice, then they'll take note of it and then differ with the inquiry report. It's better to leave it at that. They may accept it for all you know. There ends the matter.
I leave it to them. Leave it.
One step on the contentional, counsel for the petitioner submits in light of acquittal in the criminal case, question of further inquiry does not arise as the evidence in both the proceedings overlap.
Please.
And the petitioner requires benefit of acquittal to be extended in the present proceedings also. Yes.
Please, grateful.
Yes. Pass over contempt on the that. So what is the disobedience is?
There is a respond number 3.
What is the disobedience?
There was a directions to consider my representation.
So now that has been considered or not?
Not yet considered, madam.
Not considered.
They have filed memo. That's also not served upon me. I've gone through the court file last date of hearing. They have not considered. There is no endorsement also. They have not issued any endorsement.
Yes. What is your stand?
Lord, we have already sent the orders, considered orders to the petitioners through registered post.
Endorsement.
Registered post we have sent.
Where is that? ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಮುಗೀತು.
Affidavit filed by the respondent number 3 also not served upon.
3 has not filed.
On dated 5/6/2023.
3 has not filed affidavit. They only adopted affidavit of the other respondent.
Respondent number 4, yes.
We have sent the considered order to the petitioner on dated 5/6/23, sir.
A copy ಎಲ್ಲಿದೆ? You place it before the court. Let us have a look at what that endorsement is.
Right. One second. One second. Work. Details, I'll submit, sir. ಇವ್ರಿಗೆ ಕೊಟ್ಟದವ್ರಿಗೆ ಕಾಪಿ ಕಳಿಸಿರ್ ಸರ್ ಆಲ್ರೆಡಿ.
Now you have a look at this, please. You file it with the memo.
Right, sir.
Huh? You have a look at this. We'll have it when you want it.
Sorry?
When do you want it?
Day after tomorrow.
We'll have it day after tomorrow. You furnish memo filed along with the communication addressed to the Chief Engineer, Panchayat Raj Engineering Department. Same is taken on record, copy of which to be served on the counsel for the complainant. Relist the matter in same stage on 24th. Yes, next. Relist. Relist on.
First we can go to more interesting.
For the appellant in this.
Yes.
This is the case where
We are wondering, we have not seen your face for a long time. First day, one mukha toorsodre namgu one samadhan. Yes.
fortunately, my lords, I was having some engagements in
No, no.
Supreme Court and other places that.
Just like that. Yes. Yes.
So this is a case where a writ petition is filed challenging the very acquisition of the land, which was initiated under the Karnataka Industrial Areas Development Act 1966. The notification under 28(1) of the KID Act is dated 9/4/1992. Final notification is dated 14/11/1996.
28/6/4.
28/4 notification is dated 14/11/1996. The award is stated to have been passed on 17/4/2004. And it is alleged that notice under 12(2) is issued on 4/12/2007.
Yes.
The land survey number of the petitioner is survey number 162/1. Acquisition is to an extent of 7 acres and 7 guntas. This is situated in Chiksugur village in Taluka Raichur. If my lords permit me to show page number 38. The third survey number, Kannada E, Dodda E, is Chikkasugur Grama, survey number 162/1, Kshetra 7 ekre 7 gunte. In this, my lords will see at serial number 5, Buddy interest, Kabje Padedilla. And then at page number 39 and 40, At page number 40, it's the Ghoshane declaration issued by the special land acquisition officer. It says Kendra Bhuswadina Kaide 1894 ಕಲಂ 11 ಅಡಿ ರಾಯಚೂರು ಜಿಲ್ಲೆ ರಾಯಚೂರು ತಾಲೂಕಿನ ಚಿಕ್ಸೂಗೂರು ಗ್ರಾಮದಲ್ಲಿ ಸರ್ವೆ ಸಂಖ್ಯೆ 153, 154/1, 154/2, 182/1 ಮತ್ತು 170/2A. 162/1 is missing here. ಇದ್ರ ಪೈಕಿ 22.09 ಎಕರೆ ಜಮೀನಿನ ಬಾಬತ್ತು ರೂಪಾಯಿ 5,75,247 ರೂಪಾಯಿ ಮೊತ್ತಗಳಿಗೆ ಮಾನ್ಯ ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು KID ಬೆಂಗಳೂರು ಇವರು ತಮ್ಮ ಪತ್ರ ಸಂಖ್ಯೆ ಸೊ ದಿನಾಂಕ 16/11/2007 ಅನುಮೋದಿಸಲ್ಪಟ್ಟ ಸಾಮಾನ್ಯ ತೀರ್ಪನ್ನು ದಿನಾಂಕ 26/11/2007 ತೆರೆದ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಘೋಷಿಸಿದೆ.
So there is no award passed with respect to.
Award is stated to have been passed, my lords, in this page number 38, which is only a karadu samanya aitirpa. This is only a draft award. Page 28, the
Award is draft award.
they call it as karadu samanya aitirpa. They call it draft, my lords, because it is required to be approved by the deputy commissioner. Beyond a certain amount, every draft is required to be approved by the deputy commissioner under section 11 of the act. So they generally call it a draft award, but that will be the award itself. Nonetheless, my lords, in this Ghoshane dated 26/11/2007, they only refer to the 4 survey numbers.
No, but in annexure, that survey number is there.
Is there. No, their argument is, my argument is simple, my lords. No possession is taken from me, no compensation amount is paid to me. This not only violates the provisions of the new act section 24, but it violates article 300A and is contrary to article 14 of the Constitution of India.
No, correct. Now, so what is the, now this is under KD Act.
This is under KD Act.
The 24 applies even to this lapse.
It won't. That is, it won't.
So now on what ground you check?
Under article 14 and under article 300A of the Constitution, still I am protected. It's not that section 20, I cannot take recourse to section 24. But then, my lords, under the general principles under KID Act also, there cannot be an inordinate delay. That will be an unreasonable and arbitrary action of the state in saying that I will acquire the land in the year 1991 by a notification, pass an award in 2004, declare it in 2007, but don't pay you compensation, neither take the possession from you.
Till date, no compensation is.
No compensation is paid. Now, my lords, my writ petition is dismissed on 2 grounds basically. One is, after this 26/11/2007, though compensation is actually not paid to me, there is one notice which is given to me at annexure B, page number 59, my lords will see.
No, but this KID Act, different interpretations are given.
Yes, different.
Stating that the delay may not be, it vests in the state. Once it vests under 24/4 or 24/6.
24/2.
Once it vests-
24/2.
Once it vests, then they deemed.
Vesting is under 28/6 of the KID Act.
No, so I'm saying 28/6.
Yes, 28/6.
So once it's vested, that delay does not matter.
It
All
is true.
such contention-
It is true. I am not on those principles, my lords, which are akin to the principles under the land acquisition, the new 2013 Act. I am not saying that there will be a statutory bar anywhere under the KID Act for giving the compensation or for anything. I am on a different principle, constitutional principles of arbitrariness and unreasonableness, which ultimately violates article 300A. I can also connect it to article 21 of the Constitution. That's how I am trying to put up the case before you, lords. Now, lords, the writ petition is dismissed not on this ground at all. The writ petition is dismissed because what I do is, I don't get the compensation. However, a notice is issued to me now here at annexure B, page 59, somewhere in 2007. Therefore, my lords, I had also made a reference under section 18 before the civil court. That is LAC number 122 of 2008, saying that this reference is wrong.
References?
Saying that the compensation is not appropriate, is not adequate. Now, I did not disclose that in my writ petition because my writ petition is not with regard to the quantum of compensation. Now, the learned single judge, my lord, dismisses my writ petition on the ground that there is suppression of material facts. I did not disclose the fact that I have already approached the reference court, and that is dismissed on the ground of delay. My reference also is dismissed on the ground of delay.
No, correct, but when you're making a reference, you would have collected the award amount.
I have not collected the award amount. That is very clear. I will also show my lords, what is the attempt of the respondent now to show what have they done with the compensation amount. It is their allegation now that they had sent a check to the civil court as a deposit, which was never paid to me. And the civil court gives me an endorsement saying that the check which was sent to the civil court by the respondent did not mention in which case number they had to deposit this check. Therefore, that check is returned back to the government. This is all between the government and the court only, not never paid to me, nor it is deposited in my account or never offered to me anywhere. So possession admittedly is with me, my lords. Now, even till today, there was an interim order before the learned single judge throughout until the disposal. Now, if I have also filed a reference under 18, assuming that there is an award which is showing that I am entitled for some amount, whether that will stop me against the statute, will that amount to a waiver of my right or, my lords, estoppel? How is that reference?
One correct. So the logic appears to be when you seek enhancement of compensation, then you are stopped from challenging the validity of the proceeding.
Can that stop? That's the question before your lordships. And I had did this, my lords, references in the year 2008 when these principles had not yet, my lords, come to the fore. Neither 2013 Act was there, nor was there any judgment like the Pune Municipal Corporation or the Indore Development Authority judgment of the Honorable Supreme Court saying that if there is a delay in payment of compensation or not taking of possession, then I can still agitate the very acquisition itself. That ground was not available to me then. However, it's a matter of fact, my lords, that the reference is made. And it is also a matter of fact that the reference is dismissed on the ground of delay. I did not pursue it further as far as the instructions which I have with me.
No, then let us see. Now you must place all records. You place records.
My lord, my information as per the letter, my lord, the amount was sent to the
So now
reference court.
correct. Now, apart from whatever legal you place on record regarding possession and regarding payment of compensation. On that aspect, you place it
No,
on record.
amount is not paid, my lord. I have verified the file, I fairly submit and also inquired. The check, the office was changed from Dharwad to Gulbarga. KID office earlier, it was in Dharwad. The amount was sent insofar as survey number 153, 154, 54, 154, 162. Together, my lord, the total amount was sent, my lord, 44 lakhs and odd. But the same was returned.
So that Karadu Aitirpu is the award. Is it?
Yes, ma'am, that is admitted. Award is there. After we have issued the 12-2 notice, my lord, there is as the senior counsel submitted, the dates are also not disputed. The 4-1 notification, 28-1 notification, 28-4 notification, date of award and date of issuance of the 12-2 notice. 12-2 notice to receive the award amount. My lord, he has received the 12-2 notice, but he has not approached the office to collect the money after submitting the papers. Therefore, the money was sent to the reference court. On the other hand, he filed the 18-1 application for referring the matter to the civil court. And the matter was referred, LAC was registered, but the LAC dismissed. My lord,
What happened to that amount?
the amount, my lord, it was sent back to the again KID office. The total amount, the endorsement of the civil court, my lord, accounts officer.
Okay, so what is the effect of that? Now they are challenging, they're saying forget about lapse.
No, yes,
No,
yes.
They're saying if money is not paid and possession not taken, you take it in writing letters. They're taking two grounds.
Please.
Money not paid, possession not taken.
Only money is not paid, my lord, it is with regard to the possession, I have to assert. Only with regard to
You
possession.
take it on record. Place
Please,
place some pleading on record.
Please, man.
In so far as the notice, my lords, which says that they had given me a notice of the award, that is at page number 59. As I understand, my lords, the award can be if it is the argument that I had to approach the land acquisition officer on the day when the award is to be pronounced, that is the day when they will offer me the amount. Only when I don't go there, Then was 12-2 notice, and thereafter I should, they should offer me the amount. And since I did not go when they called me to the office, now there is no question of me saying that they did not pay me. This is the argument. But that is contrary to the document at page 59. My lords have seen the Ghoshane at page 40, which says that on 26/11/2007, the award has been pronounced after approval from the Deputy Commissioner. At page 59, this is dated 4th of December 2007, saying that I should come on the 20th of December 2007 to their office. Now, this is not the date of pronouncement of the award. Award has been pronounced in the month of November.
Yes, my lord.
Once that award is pronounced in the month of November, then there is no question of me. Now they're saying that they offered it on the day when the award was pronounced. I was not present there. It is my choice. And therefore, now I cannot complain. That argument is not available to the government. This is what I respectfully submit.
Yes.
Nonetheless, today, as a matter of fact, amount still lies with them. Possession, as per the notification itself, shows I'm in possession. And I was protected by an order of status.
Not as if they did not offer you the money, isn't it?
They did not offer me the money.
No, award.
That is not sufficient. Offering the money, my lords, by the very pronouncement of the award, there is an offering of money to everybody under the award. That is not sufficient at all. They will have to offer in the sense, my lords, they should actually pay me the money. And if I refuse to receive that money when they pay it, then they can deposit into the, maybe in the RD or maybe before the civil court. They did not deposit in my LSC.
Did you file objections before the single judge?
Yes, they
Filed.
filed, they filed.
They filed.
The only argument, the only contention there was that notice was issued to me.
Yes.
And that I have suppressed the filing of LSC 122 of 2008. So they did not say that possession is not with me.
You take your stand in writing, let's see. The Learned Senior Counsel appearing on behalf of the appellant would submit that award amount has not been tendered to the appellant, nor possession taken. Such aspects requires perusal of records with the respondent. Respondent to take their stand in writing on the above two aspects and produce relevant records. Relist the matter on.
My lord, if I can request this, my lord, since it is his oral submission on instructions, probably that compensation amount is lying with the government.
Now we have asked.
That can be recorded.
We have asked him in writing. Let it come in writing.
On the papers and files, I am submitting.
Correct. Now you take it in writing.
With regard to the possession only, I have to.
Let us
Please.
relist the matter on.
Monday.
Monday.
29th.
Third of February.
Please.
Instead of 3rd, could it be on 4th if I can request?
4th.
Great.
ಇದು filing. Yes.
No, this is Tej Patak.
Correct. They are the 28th. So we have posted those other matters on 28th.
20th, I am told, my lord.
We'll have it on the same day. And then we'll hear all the counsel on the scope of this judgment and then take up case by case. Relist on to 28th. Now this supports you or what?
Yes, my lord. There cannot be any change of once a notification. The recruitment process ultimately holds that the recruitment process starts from the issue of notification, ends with a selection. And in the process, it is made clear that no changes could be made.
Now we had passed some direction, isn't it, against the respondent?
ಅಲ್ಲ ಹೌದು ಹೌದು ಅದರಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಬಂದಾಗೆ ಒಂದು 1:5 ಇರೋದು. ಐ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಡೌಟೆಡ್ ದಟ್ ಹೌ ಮೆನಿ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಅಪ್ಲೈಡ್ ಅಂಡರ್ that post under rural, gender rural. I mean, 1:2 ratio is supposed to be called for interview. And in the KPSC, it has been held if it is not falling within the 1:5.
So who appears for R1 to R3?
Not the Gaurish Kashampur.
Huh?
Mr. Gaurish Kashampur.
I'll pass over. You just ask him. He has to comply on the 20th. He has to produce this.
I'll ask him.
I'll adjourn it or later.
It could be taken up on 20th. I'll communicate to your lordships. to him.
My lord, the issue, my lord, the earlier, I think in on August 24, there was some order passed by your lordship only. There itself, 1:5, how many applied under that category? Because 1:5 is the ratio for calling for the interview, my lord. So I doubted that.
Respondent 1 to 3
Yes.
to comply with the order dated 38/2024 as well as 10/1/2025.
Yes.
Relating to production of relevant records.
Please.
The learned counsel for respondent 1 to 3 to take note of the observation in the order dated 30th August 2024 and 10th January 2025 and ensure necessary records are produced on by the next date.
1 and 3, your lordships. Respond number 1 and 3.
1 and 3.
Yes.
Relist on 28th. Yes. Date good. First week will be good. First week. That's all. Next. Yes.
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 It's a first appeal, my lord, a suit for partition and separate position was decreed, granting 1/5 share, 2/5 share to the plaintiffs and 1/5 share to other defendants. Unfortunately, I have not filed a written statement and not cross-examined. Therefore, alternately, I sought for a remand.
You take out notice, let him come with.
The interim stay, at least drawing of it because it is first
I'll
appeal,
note
my lord.
Let it correct expert ಅಲ್ವಾ? At
ಇಲ್ಲ
least
ನಾನು ಎಕ್ಸ್ಪರ್ಟ್ ಇದ್ದ
ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರನ್ನ ಕರ್ಸಿ ನಾವು FDP ಹಾಕಿದಾರ.
ಅದು
You serve on them, we'll have it next week.
Ah.
We'll see what is to be. Emergent notice to the respondents. Appellant is permitted to serve counsel appearing for the respondents in the final decree proceedings. Relist on date good. 30th.
Yes, my lord.
But I appeal for respond number 2 to 4, my lord.
Yes.
My lord, against this order, my lord, already yesterday has given an undertaking. Yesterday, we had went to demolish the property. He has given an undertaking that he is going to demolish himself, my lord. I'll produce that copy, my lord.
Yes, sir.
He has given an undertaking, my lord.
So when do you want it?
They had moved the matter, but yesterday, part of the portion is demolished. Setback ಎಲ್ಲೆಲ್ಲಿ ಏನು ಇದು ಮಾಡಿಲ್ಲ, that portion has been demolished. Remaining part, he himself has undertaken that he is going to demolish it, my lord.
ನಿಮಿಷ ಕೊಡಿ.
The learned single judge that
Let him
please.
come, we'll pass over, let us see.
Please, my lord.
Huh?
Please.
What is this residential premises? Huh?
Residential premises, earlier he had applied for the construction permission, which was rejected because he had already constructed the property. Once again, suppressing that fact, Suppressing that, he again applies for the construction permission.
Pass over, let him come. Now he is himself demolishing.
He himself has given an undertaking that he is going to demolish, my lord.
So he has
Part
saved-
was demolished, then
he saved your cost.
yes, my lord. Earlier actually this letter single judge directed that to demolish by himself. If he doesn't demolish, then direction was given to us to demolish. Now he has undertaken that he is going to demolish.
Yes, please. It's for admission, man. Admit.
498A and 300.
And TCR. Yes. Admit ಆಗಿದೆ ಮತ್ತೆ ಇನ್ನೇನಕ್ಕೆ ಬಂದದ್ದು ಅಷ್ಟೇ. Your matter is already admitted. Your matter is already admitted.
ಆಗಿತ್ತು ಅದೇ admission ಮತ್ತೆ ಬಂದದ ಅದಕ್ಕೆ
But once again, it
Call
has come for
list,
admission.
ಕಾಲ್ ಫಾರ್
Finding
ರೆಕಾರ್ಡ್ಸ್
any-
ಮಾಡಿ
Or as per seniority.
Yeah.
Paper books
ಪೇಪರ್
prepared. Yes, next. Relist. Put it.
Lord, this matter more is, my lord, yesterday it was heard, man, and they were supposed to, my lord, make submissions the other side.
Huh? 230, we have 302. 498A, 302. No, okay, 230 you come.
Yes.
230. Because of Subhash Mallapur, we are keeping it 230.
So I have one judgment, my lords.
Put
Yes,
it, put
yes,
it,
put it.
put it, 230. Pass over, Kedan. We will give a different date. Huh? 37.
37.
What is the matter?
Matter pertains to compensate appointment, my lord.
Hmm.
The respondent herein filed an application for the
37. Ready now or will take
Till
it?
it will be taken on next week.
Relist on date good.
this pertains to 2019. I'm seeking for a compensate appointment, my lord.
Let us see. Come ready, file a
The
synopsis.
issue involved in only one, they have stating that, my lord, I have not given the representation within a 1 year. My lord. Earlier, my mother was given within a 1 year of death of her husband, my lord. They have not considered that. That is the only issue involved. in
Correct.
this.
Applicant is the son.
Applicant is the son.
Correct. You are a major,
No,
Yes, my lord, I'm a major.
at the time of death, he is not major.
not major.
Yes.
Yes, I'm a major man. I'm the major, my lord. Earlier, what happened, my lord? The elder son is given the representation, my lord. They have stated that, my lord, he has crossed the age limit.
No, then you
Subsequent, I have given the
you file a synopsis. Synopsis to be filed. Relist the matter on. Yes. File a synopsis by the next. Yes,
any date may be fixed. Ma.
10th.
Lordship, one submission,
Yes,
one habeas corpus, kindly tomorrow,
tomorrow.
please.
Scrutiny ಮಾಡಿಸ್ಬಿಡಿ.
Yes, my lordship.
ಸ್ಟೇಟಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟಿರಿ.
Yes, my lordship. I
Advance.
served earlier.
Huh?
Already served.
See, some habeas corpus, you make a note of it.
Please, ma'am.
It will come tomorrow. Meanwhile, telephonically, you get some instruction.
Please.
As soon as you file, before you move a memo, if you tell them,
Yes.
instead of waiting for tomorrow, they
Yes,
will see
ma'am.
what they can.
My lord, on submission,
Yes,
serial number 39, my lord, I'll be submitting some decisions right now to the court officer, my lord.
Yes, yes.
Number ಬರ್ಕೊಡ್ರಿ.
Published.
ಹೋಗು. ಏನೈತೆ? ಮಲ್ಲಾಪುರದ ನಮ್ದು ಏನೈತೆ?
Court officer? Court officer?
25th. Released on 25th.
Construction permission without demolition and
You have undertaken to remove,
Yes, my lord.
undertaking ಕೊಟ್ಟಿದ್ದೀರಂತೆ.
Yes, yesterday.
Huh?
Yes.
Huh.
But the appellant's grievance is that G+2 ಇದೆ, ಮೇಲೆ 2 ರೂಮ್ ಇದೆ. ತೆಗ್ಲಿಕ್ ಬರಲ್ಲ, ಸೊ ಅದಕ್ಕೆ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ಹೇಳಿ ಒಂದು ರಿಕ್ವೆಸ್ಟ್ ಇದೆ ಕೋರ್ಟ್ ಮುಂದೆ.
ಅದ್ ನಾವ್ ಹೆಂಗ್ ಕೊಡೋದು?
Directions may be issued to grant permission for the 2 rooms, 2nd floor. Setback ಅಲ್ಲಿ, as per setback marked by them, will give an undertake already.
Krupa Sagar ಕರ್ಸಿ. Just call him immediately. Next.
ಅವನಿಗೊಂದು ಕೊಡ್ಬೇಕಲ್ಲ.
Just 1 minute. Yes, Krupa Sagar, they want you to give, correct, but they are saying they have made a oral request for retention of 2 rooms.
My lord, problem here is,
Asking.
ಅಲ್ಲ ಬರಂಗಿಲ್ಲ ಎದಕ್ಕಂದ್ರೆ taking this order, the order passed by the learned single judge, he has filed a fresh writ petition to obey these orders in all other cases. ಅದು ಇದೆ, ಕಾಪಿ ಕೊಡ್ತೀನಿ. This order has to be implemented in all cases ಅಂತೇಳಿ ಅವರು ಸಪರೇಟ್ ರಿಟ್ ಹಾಕಿ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ದಾರೆ ಮ್ಯಾಂಡಮಸ್.
ಯಾರು?
ಇವ್ರೆ ಅವರೇ ತಗೊಂಡಿದ್ದಾರೆ.
But in the fresh writ petition order mentioned the properties that they have
Issue
not at all.
writ of madam, second prayer, my lord, issue writ of madam directing the respondents to demolish the illegal and unauthorized construction building who are violated the rules and regulations of Municipal Corporation Act as observed in writ petition number so and so. That is the one which is under challenge.
But in the
He
same
himself seeks to implement that order.
ಎಲ್ಲಾರ್ಗೂ ಸಮವಾಗಿ
ಮಾಡಿ
ಲೋಕ ಕಲ್ಯಾಣ.
ಇದು ಮಾಡಿ ತಮ್ಮ ಇದ್ರ ಮೇಲೆ ತಾವು.
But in the said properties, my lord, they have not at all obtained the construction permission, my lord. Here once rejected and
And recently Supreme Court has also come heavily on the officers, my lord, wherever illegal constructions are being taken place. Now guidelines also.
This is the undertaking.
Yes, yesterday has given undertaking that he will demolish himself whatever the marking has been given.
Correct. So what remains now?
the request of the appellants that the G+2 is there, upper set 2 rooms are there, so the directions may be issued to the authority to give permission for that.
What is the 2 rooms? How much square feet? How much square feet? Then terrace room, there will be some provision. Terrace room, lift room.
That's why the learned single judge only said, my lord, corporation would be at liberty to demolish the construction violation wherever there is only violation, that we have to demolish, not remaining portion, my lord. Only wherever there is a violation, that's all. So violation we already marked and given to him. As he didn't demolish yesterday, we went and demolished part of it. Then he given undertaking that I only will demolish the property as per.
So correct. So what is the clarification now? That you have to work it out with them. We cannot give a direction. If there's any way it could be saved, they will look into it.
And one more thing, what he has done, he has filed separated to implement this order for all of them, which he himself says this order has to be implemented everywhere.
ಆಯ್ತು, ಅದು ಅವ್ರು ಕೇಳಿದ್ದು ತಪ್ಪು, ನಾವು ಕೊಟ್ಟಿದ್ದು ತಪ್ಪು.
ಅದು actually it is a PIL, my lord, we have sought for
ಮತ್ತೆ
challenge, time ಇದೆ challenge ಮಾಡಕ್ಕೆ ಇದು ಮಾಡಿದ್ವಿ.
ಅಲ್ಲ ಆಯ್ತು, that's a different matter.
Yes, my lord.
Now correct. Now whatever other request you have, it's open for you to give it to them.
He can give it, let them consider, my lord. But as now he has given undertaking that he is going to demolish.
The remaining, it's up to you. We will not say anything. It's up to you to give them representation. They'll look into it.
Yes.
If law permits, they look into it.
On that observation, writ appeal may be discussed.
ಅಲ್ಲ ನಾವು ತಿರ್ಗಾ ಏನೋ ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ ನೀವು ಮ್ಯಾಂಡಮಸ್ ಕೇಳಿ ಒಂದು ಕಂಟೆಂಪ್ಟ್ ಹಾಕ್ಬಿಟ್ಟು
ಇಲ್ಲ ಅದು ಸಪರೇಟ್ ಅವ್ರು ಬೇಡ. Let him give.
ಕರೆಕ್ಟ್ ಕೊಡಿ.
I'll instruct the officials to consider.
ಹಾ. The present, no, but we should appreciate that he has at least come forward to remove it voluntarily.
ಅಲ್ಲ, there was a direction. First ಅವರಿಗೆ ರಿಮೂವ್ ಮಾಡಂತ ಹೇಳಿದ್ರು. ಮಾಡ್ಲಿಲ್ಲ.
ಸ್ವಲ್ಪ ಕ್ರೆಡಿಟ್ ಕೊಡ್ಬೇಕು.
Entire
ಆಯ್ತು, ಅವ್ರು ಇವಾಗ when they're conceding should make them feel comfortable.
The reason I will say, my lord, because if corporation starts demolishing, they will demolish without any markings. Corporation demolish ಮಾಡಕ್ ಹೋದ್ರು without any markings ಸಿಕ್ಕಂಗ್ demolish ಮಾಡ್ತಾರೆ. ಅವ್ರಾದ್ರೂ they can get it neatly done. That is the reason he said he will demolish himself.
But you look at it positively.
Yes, yes.
They have
my lord.
come forward
Yes.
to comply with the law.
Yes, my lord.
The present writ appeal is filed against the order passed in WP 201697 of 2024, whereby the learned single judge had dispose of the writ petition, passing certain observations relating to removal of construction in violation of plan and law. Had whereby the learned single judge had disposed of the writ petition, directing the respondent corporation to make inspection of the property of the petitioner and demarcate the area which is constructed in violation of the building bylaws, and to call upon the petitioner to voluntarily demolish the said violated construction. During the pendency of the said proceedings, it is submitted by learned counsel appearing for the respondent corporation that an undertaking has been made by the appellant to remove voluntarily the constructed portions in violation of law. A copy of the said undertaking is produced along with the memo. The undertaking reads as follows. Next, in light of the same, there is no further cause for adjudication. Taking note of the undertaking made, placed before the court, we find that the direction of the learned single judge insofar as removal of constructed portion in violation of law has been complied with. Accordingly, the writ petition is disposed of as not calling for any further adjudication.
Fresh representation, so observation.
That you give it.
I will instruct, my lord. If he gives, I'll immediately instruct them to consider.
You give it immediately. Let
Please.
it be contemporaneous with this.
Please.
Now, the single judge has said, after the sketch is prepared, what can be regularized must be done. There ends the matter, so they'll consider.
Yes, let them give, my lord. We will.
Please. Yes, what is the judgment you're relying on? What is the judgment you're relying on?
Lords, I'm relying on the judgment interpretation of Lords.
Really?
It may take some time, Lords. Lordship has- A 3 judges bench, my Lord. Rajasthan also same thing.
You are correct. This Kim Singh.
Yes.
It says that both are different. Both are different. Criminal case and DE are different parallel proceedings.
No, here what has happened, my Lords, that Hem Singh was a head constable.
Correct.
Yes, my Lord.
The principle laid down is that mere acquittal in the criminal case.
No, no, Lords, there is a interpretation, my Lords, how to, in this case, what has they have stated is, in a departmental proceeding, the charges framed are not only with the extent here, he was involved in a conspiracy of murder case, my Lords. It was not the only question, my Lords. It was that he was absent during that period. Here also, so the charges leveled has also be taken into consideration.
Only the charges, what we are saying,
Yes,
we're going one step further.
Yes, ma'am.
In the DE, what is the charge frame?
Yes, yes.
Only that must be looked into.
Yes.
We need not enter into the criminal case.
Yes.
And here,
Yes.
only on that charge we're going to decide without
Yes,
entering
yes,
into
yes,
the.
ma'am. Yes, ma'am. So, if your Lordship, the charge, my Lords, may I read the charge in the?
Yes.
Page 40.
Page?
40.
Four zero, my Lords.
Yes, yes.
Charge, my Lords, annexure 1. You, DGO Akkamadevi, so were working as the second division office by of the Deputy Director Public Instruction Department, Bijapur, when approached by Dattatreya Kesharov Kulkarni, teacher in Satya Sai High School at Bijapur, seek permission for the DDPI office with respect of 14 students intending to take SSLC exams as an external candidates by making necessary remittance of fees of rupees 185 by each candidate. You, DGO, dealing with the said section at DDPI office, failed to put up the file and accord the permission as sought by the complainant. The complainant approached you on 18/8/2012 asking about the permission. You somehow asked him to come the next day. When he came the next day, you again post of 200 rupees per candidate to get the permission of the then. At the request of the complaint, you reduced the bribe amount to 2,000. The conversation took place in the complaint is recorded in his mobile. You, DGO, demanded and accepted the said bribe amount 25/8/2002, doing an official act hereby failed to maintain the absolute integrity and besides devotion to the duty and committed an act of unbecoming a government servant. Here, my lords, it is not only bribe, my lords. she has caused inconvenience and her act, my lords, of unbecoming a public servant. Now, if we go into the evidence, my lords, of PW1, he has, in the cross-examination, he has told that due to the pressure exerted by those students, my lords, because they were eager to give exams as an externals, she was not cooperating. He went and lodged the complaint. And my lords, he, in the examination chief also, my lords, he has accepted that this complaint is, he has submitted the complaint before the Lokayukt. So the question now, and the second question is, my lords, presumption. The money is recovered from her, my lords. Even though she has refused, how did it come under and in her drawer? It is not her case that he forcibly put it inside her
No,
drawer.
that explanation is there. The money was pushed, it fell into the drawer.
If it is pushed, it should go outside, my lords. How it
Don't know.
came under?
That we don't know.
There, my lords, the probability works, my lords. My argument is that probability works because the money is recovered from her and she has not given the satisfactory answer. She would have told you, in spite of me resisting, he forcibly opened the drawer and he pushed it inside my drawer. By the time the Lokayukt officials came and it is not her case, my lords. In her examination also, she has not narrated that fact, my lords.
She has not.
So looking into,
has
so
not
there are
made-
two charges. So one is she was not cooperating deliberately by avoiding to process the application by the 14 students. Here, the complainant is not an interested person. He was on behalf of those 14 students. He was trying to negotiate to get the permission for those 14 students to get enter examination and give examination. So these two aspects, my lords, in the judgment, I have, and my lords, honorable acquittal, I will interpret.
We are not looking into the criminal judgment of the criminal court. We are not going to refer to the findings of the criminal court. Independently, we look at the evidence only in this.
No.
But one thing in the even at Ramanal
Minutes. Para 34, my lords, at page number 22. That's in my judge, in the three judges judgment, my lords, last para.
The charges were not just
Last para.
Reported in 2024, I think.
Is evidence bad?
Yes.
Here also, my lords, the main witness, the shadow witness has not been examined in either in that court or this court. My lords, may I take your lordship to last pair of the my judgment?
One thing in a judicial, we know, we are aware that in a judicial review, in a disciplinary proceedings, judicial review, the scope is very limited. Yes. In a criminal case, that is beyond reasonable doubt, and wherein in DE,
probability, that's all, preponderance and probability. Now, at least to prove preponderance and probabilities, the witness has to support, we have to go with the evidence, alva. We have to go with the evidence.
Yes, my lord.
While discussing, you just go through the evidence of PW
That's what,
one,
my
two
lord.
and three.
The evidence here, it can disprove that there was a demand and acceptance by there was demand, my lords, but acceptance is there since the money was in our possession. As far as demand is concerned, as your lordship observed, there is no demand. But the probability, my lords, why the applications of those 14 persons of students were not processed in time. That's what my judgment.
Who has
I
to
mean,
say?
and the next one.
Examine some witness to that effect. There is no such evidence, at least some evidence.
Only two paras, my lord, that is partial, my lord, supporting the case. He says, the complainant says, he approached, he lodged the complaint for against the, my lord, DGO for the demand of 2,000, and subsequently he denied. Therefore, my lord, it's a partial, my lord, hostile, partly supported. No man will go, my lord, against any person for lodging a complaint without there being any demand. Here there is a demand for the harassment made by the DGOs. He lodged the complaint, and after lapse of gap of time, my lord, he turned hostile in criminal case. But in the cross-examination of the, my lord, the lady, she, suggestions she denied. Then all the suggestions denied, but there is a, why the ಕೈಗೆ ಯಾಕೆ ಬಣ್ಣ ಬಂತು ಅನ್ನೋದಕ್ಕೆ ನಾ ತಳ್ಳಿದೆ ಅಂತ ಅಂತಾರೆ. ತಳ್ಳಿದ್ರೆ ಇಷ್ಟೇ ಒಂದೇ ಕ್ರೂಷಿಯಲ್ ಪಾಯಿಂಟ್. ಡ್ರಾದಲ್ಲಿ ಬಿತ್ತು ದುಡ್ಡು ಅಂತ, ಡ್ರಾದಲ್ಲಿ ತಗೊಂಡಿದ್ದಾರೆ ದುಡ್ಡು. ಬೇಡ ಅಂತ ತಳ್ಳಿದಾಗ ನನ್ ಕೈಗೆ ಬಣ್ಣ ಆಯ್ತು ಅಂತ ಅರ್ಥ. ಆ ಅಮ್ಮ ಹೇಳೋದು. ಬಟ್ ತಳ್ಳಿದ್ರೆ ನಾರ್ಮಲಿ ಡ್ರಾನಲ್ಲಿ ಬೀಳಲ್ಲ, ಡ್ರಾ ಯಾವಾಗೂ ಓಪನ್ ಇರಲ್ಲ. This is the only. It is not her case that the complainant forcibly put that.
Even admitting that circumstance also. The mere recovery constitutes.
No, no. So as far as trap is concerned, I am not arguing.
Mere recovery.
For becoming, for unbecoming a deliriance of duty, I am on that ground.
Unbecoming, there must be a demand and acceptance.
Yes, my lord.
Demand and acceptance.
Yes, my lord. So
where is the acceptance? Where is the demand?
My lord, so the complainant has admitted that, my lord, in the cross-examination that he was forced to, my lord, even though he has turned hostile.
Yeah, your suggestion, just go through the evidence once again for your satisfaction. Where is the evidence? I thought evidence ಬೇಕಾದ್ರೆ ಓದಿ.
And my lords, PW2, my lords.
Where is its evidence? Page number. PW1 evidence ಓದಿ.
Cross. From page number 77.
Page number 84 ಗೆ ಬನ್ನಿ, cross.
84. It is true that on 18/8/2012, it was Saturday. It is true that it was Sunday, and 28/2000 was general holiday of Ramzan. I don't know that on 21 the DGO had completed the work and forwarded the file to the DDP. It is true that on 22 the DGO informed me that her part of work is already complete. It is true that MG Shri Rati was outward clerk. On 22/8/2012, I did not meet MG Sirati. I do not know from 23 to 25, Sri, I was on leave. On 25, all the students came to me to meet DGO. It is true that on 25, the DGO informed me that her part of work is complete, and she asked me to correct the year in all the application. It is true that therefore the student took me to Lokayukta office. It is true that in Lokayukta office, the students also informed the police that till today the work is not completed. It is true that the Lokayukta police informed me to get the work done completed earlier. The students have lodged the complaint. It's true when the students forced me, I have signed. My lords, may I take your lordship to evidence of PW2? in para 5, PW, evidence of PW2.
PW2.
Yes.
Ah.
I also sees the documents pertaining to the students as per exhibit P5, the Tuesday has given her statement. It was still on her table, Manoj. And a statement before, and IO, and has given her statement before IO stating that the complainant has given money forcibly. So she has accepted, Manoj, in the cross examination. That part.
The forcibly, acceptance thing.
That's all. When
Three judges judgment, yeah.
ಓದಿದ್ದೀವಿ ನಾವು ರಾಮ್ಲಾಲ್ and this judgment.
Alla, Ramlal, one interpretation. Ramlal case. In Ramlal case, it is not honorable acquittal, Manoj. He was acquitted when wherein the prosecution had failed, Manoj. Here in this case and my other case, Manoj, because they have done technically, here the shadow witness was not examined. So technically he was there acquittal, Manoj. In Ramlal case, it was honorable acquittal, and it was not case of the inquiry officer that his appointment was based on 10th marks card, Manoj. So these two aspects, Manoj, when the requirement for appointment was not 10th standard. So question of Manoj, him proving that he has passed and does not arise. On that aspect, Manoj.
No such a concept of honorary acquittal or acquittal in a criminal jurisdiction. Where is the concept?
Here in this case, Manoj, they have.
ಇಲ್ಲ ಸುಮ್ಮನೆ ಅದರಲ್ಲಿ ಎಲ್ಲಿ
ಸುಮ್ನೆ
ಮಾಡಿದ್ದಾರೆ?
acquittal ಬರೀತಾರೆ ಆ ತರ honorable
ಏನು honorary acquittal
ಹೌದು,
is
ಬರಂಗಿಲ್ಲ,
acquittal.
ಬರಂಗಿಲ್ಲ. ಯಾವುದ್ರಲ್ಲೂ ಬರೆಯಲ್ಲ.
The challenge in this petition is to an order dated 23/8. The challenge in this petition is to an order dated 23/8/2021 passed by the Karnataka State Administrative Tribunal, Kalaburagi, hereinafter case. In application number 20/819 of 2020, whereby the learned KSAT has dismissed the petition application filed by the petitioner here in Pulsha. Next, the facts apposite for consideration as borne out from the pleading are as under the petitioner was working as the SDA in the office of DDPI of Vijaypura, one Sri Kulakarni lodged the complaint before the Lokayukta Police Vijaypura, alleging that he made an application to the petitioner for issuance of hall tickets in respect of 14 students to appear as external candidates for SSLC examination from Satya Sai High School, Vijayapura, for which the petitioner had demanded a sum of rupees 200 per student to meet the request. Full stop. When the complainant expressed his inability to pay the said amount, the petitioner informed him to pay in all 2,000 to consider the request. Full stop. As such, the complainant registered complainant informed the same to the Lokayukta by lodging a complaint. On the strength of this complaint, the Lokayukta police, Vijayapura, the Lokayukta police registered the same in crime number 13 of 2012. Full stop. Thereafter, a trap was laid on 25/8/2012, and consequently, the FIR submitted before the Special Judge Vijayapura against the petitioner for the offence punishable under the provisions of PC Act 1988. Full stop. Next, based on the investigation report of Lokayukta Police, the Honorable Upalokayukta filed a report under Section 12 of the Karnataka Lokayukta Act 1984 on 13/12/2013, recommending to the competent authority to initiate disciplinary proceedings against the petitioner and to entrust the inquiry to the Upalokayukta institution. Full stop. Thereafter, the government, that is the Principal Secretary to Government Education Department, primary and secondary education, has entrusted the matter to conduct the disciplinary inquiry, has entrusted the matter to Upalokayukta to conduct the inquiry under Rule 14A of the KCS LCCA rules, CC rules 1957, wide order dated 18/2/2014. Full stop. Accordingly, the inquiry officer nominated by the Upalokayukta and framed the articles of charge on 31/12/2014 as under para page 40 ಅಲ್ಲಿ 41 ಅಲ್ಲಿ 41 ಅಲ್ಲಿ ಇದನ್ನ ಎಲ್ಲಿಂದ 41 ಇಲ್ಲಿ ತನಕ 41 full stop. Next, in order to prove the charges, the disciplinary authority examined disciplinary authority in inquiry number 164 of 2014, examined 3 witnesses as PW 123 and PW 123. That is the PW 1 is the complainant. PW 2 is the Mahazar witness.
He is a punch witness.
He's a punch witness for the trap proceedings.
Yes.
For the trap proceedings, and PW 3 is the investigation officer. So also marked how many documents?
Documents it is at page 126.
Yes, to how many documents?
EXP 1 to EXP 14.
HP 1 to sorry. In 14 documents as exhibit to P1 to P14. Full stop. Full stop. However, DG, the petitioner himself examined as the DW1.
Herself.
Herself examined as DW1. So also got marked one document, two documents that is exhibited D1 and D2, full stop. After assessment of the oral and documentary evidence, the inquiry officer, submitted the report to Lokayukta, to the Upalokayukta on 31/8/2018, sender. 125 ಇದೆ 125 ಅಲ್ಲಿ ಇದನ್ನ ಆರ್ಡರ್. This is the order ಅಲ್ವಾ?
Yes.
125 order ಇದನ್ನ order ಇಲ್ಲಿ as under full show. Based on the said above report, comma, the Lokayukta recommended, so Lokayukta recommended, made the recommendation, and Lokayukta made the recommendation to the government on 3/9/2018.
Yes, ma'am.
3/9/2018. ಎಲ್ಲಿದೆ ಅದು?
Page 94.
Page 94. Made the recommendation on 3/9/2018, 18, as under para 7 ಅಲ್ಲಿ ಹಾಕು. para 7 ನೋಡಿ page 96 ಅಲ್ಲಿ ಇದೆ para 7. para 7 ಅಲ್ವಾ?
Yes.
para 7. Imposing penalty ಅಂತ ಇರ್ತದೆ. para 7. Next. The accordingly, based on the said recommendation, accordingly, the government order has been passed wide GO dated page 36 ಇಲ್ಲಿ ಎಷ್ಟಿದೆ? Wide GO bearing number ED 293 STB 2019 dated 24/11/2020.
Yes.
2020.
Yes.
2020 by the first respondent, and order of compulsory retirement.
Yes.
By order of compulsory retirement to the petitioner under Rule 8 subclause 6.
Yes.
8 subclause 6 of KCS bracket ali CCA Rule 1957. Full stop. Agreed by the said order, the petitioner approached the Karnataka Appellate Tribunal in application number 20819 of 2020, wherein the tribunal dismissed the petition application filed by the petitioner as stated supra. Full stop. The challenge to the same is placed before this court. Next, we have heard the learned counsel Shri Patil for the petitioner. So also Shri Mallapur for the Lokayukta respondent number 2, respondent number 2, and Shri Tengumali for the state respondent number 1.
Yes.
Respondent number 1. Next, it is the primary contention of the learned counsel for the petitioner that the inquiry officer, the order passed by the respondent number 1 based on the recommendation of the based on the recommendation of the government, in view of the order passed by the inquiring authority. Inquiring authority is totally erroneous and without applicable of mind. Full stop. Mind. According to the learned counsel, the witness examined before the disciplinary proceedings.
Inquiry.
That is the inquiry before the inquiry officer. before the inquiry officer, comma, though the authority examined 3 witnesses as PW 123, comma, the complainant, that is PW 1 himself totally turned hostile to the case, total hostile to the case. Full stop. He denied the contents of his complaint lodged before the authority, before the Lokayukta. So also he denied the, so also he has, so also he has stated that all contents of exhibit P1, the complaint, and also about the proceedings, about the trap proceedings, and also in respect of the trap proceedings, full stop. He would further contend that though the PW2, the Pancha witness for the trap proceedings supported the case, however, is totally a hearsay. He is not an eyewitness to the incident, and according to him, PW1 alone entered the chamber of the petitioner, entered the chamber of the petitioner, and thereafter entered the chamber of the petitioner, and thereafter he gave a signal to the PW2 and PW3, and thereafter they visited the chamber.
One small
They
correction.
entered.
One small.
Ah.
The complainant, my lord, along with another punch witness, Shri Chandrasekhar,
That
both
shadow
of them,
witness-
they entered the chamber.
Entered.
But Chandrasekhar has not been examined.
That witness has not been examined.
The complainant and
And shadow
PW1 and a shadow witness,
Shri
one
Chandrasekhar.
Chandrasekhar,
Yes.
have entered the chamber of the accused,
Right.
chamber of
DGO.
the petitioner, petitioner. However, they said the Chandrasekhar shadow witness has not examined in the disciplinary in the inquiry proceedings.
And even in the criminal case.
Inquiry proceedings. And according to the PW1, comma, according to PW2, comma, PW1 has gave a signal to the PW2 and PW3, and thereafter they entered the chamber. In such entered the chamber. However, PW1 himself turned hostile to that effect, or to that effect, comma, the credence cannot be given to the evidence of, attached to the evidence of PW2, full stop. Moreover, full stop. He also contends that, PW1 clearly denied the demand of illegal gratification by the petitioner, for the work done, for the work which pending before him, full stop. As such, the authority totally failed to prove the demand and acceptance of the illegal gratification by the petitioner, full stop, by the petitioner. Though the authority has examined PW3, the investigation officer, before the inquiring authority, he also stated that based on the information of PW1, he visited the spot and conducted the mahazar, full stop, conducted the mahazar and recovered the tainted money, tainted currency, full stop, tainted currency. In such circumstance, comma, the authority has totally failed to place any evidence, any believable evidence, reliable evidence to prove the charges leveled against the petitioner, Accordingly, the learned counsel submitted that this case has to be treated as a no evidence case, and the findings of the disciplinary authority is totally perverse in nature, full stop. With these full stop, in order to to buttress his argument, he relied the following authorities ಅದನ್ನ ಹಾಕ್ಬಿಡಿ following judgments ಎಷ್ಟಿದೆ ಅದು
My lord, ಅದರಲ್ಲಿ in additional documents and more particularly, my lord, Kuldeep Singh, more particularly,
ಮಹೇಶ್ ಪಾಟೀಲ್ ಇದೆ ನೋಡಿ ಇಲ್ಲಿ ಇದೆ ಅಲ್ವಾ
additional document.
ಮಹೇಶ್ ಪಾಟೀಲ್ ಇದೆ this is
Yes, sir. Yes.
ಅದ್ರಲ್ಲ
Page number,
Yes, ಅದನ್ನ ಹಾಕೊಳ್ತೀನಿ ಅಥಾರಿಟಿ 1 2 3 ಹಾಕೊಳ್ಳಿ 1 2 3 ಅದನ್ನ ಹಾಕಿ
my lord, insofar as,
ಕೇಸ್ ನಂಬರ್ ಏನು
my lord,
ಹಿಂಗೆ 1 2 3 list ಇದೆ to buttress his argument he relied the following
may I make one submission?
yes
Here, my lord, 7 citations, my lord, I have produced. Insofar as, my lord, no evidence and wrong interpretation of oral evidence, my lord, first three. my lord,
I'll come.
Please.
I'll come. Yes, next. The per contra, she Malapur, learned counsel appearing for the respondent number 2, Lokayukta, would vehemently contend that this is not a content that, comma, the KSAT has rightly rejected the application filed by the petitioner by confirming the order passed by the government passed by the government. So also government and the report and also the report or recommendation made by the Lokayukta, full stop. According to him, the ಮೇಲ್ಗಡೆ ಒಂದು ಪಾಯಿಂಟ್ ಹಾಕೊಳ್ಳಿ ಮೇಲ್ಗಡೆ ಮಹೇಶ್ ಅವರದ್ದು he also contend that ನಿಮ್ದ್ರಲ್ಲಿ he also contend that the petitioner is acquitted in the criminal case that is filed by the Lokayukta police in crime number in special case number ಅಂತ in special case number ಎಷ್ಟದು
Yes. 6/2013.
6/2013, wide judgment dated
13th April
2015 by the principal session judge / special judge at Vijaypura. Nevertheless, the said judgment was confirmed by this court in criminal appeal number
2009015.
20090 of 2015 dated
14/7/2016.
ಈಗ with this buttress argument ಅದನ್ನ ಹಾಕೊಳ್ಳಿ ಈಗ ಇಲ್ಲಿ ಏನಾಗ್ತಿದೆ made by the Lokayukta, full stop. According to the learned counsel, the authority has examined the 3 witnesses before the inquiring officer, and among them PW1 is the complainant, though turned hostile to the prosecution, during the course of cross-examination, as admitted to the effect that he has lodged the complaint before the authority, before the Lokayukta immediately after the incident. As per the complaint exhibit P1. As per exhibit P1, full stop. Further, PW2 and PW3, PW2, the independent punch witness for their trap proceedings clearly supported the case of prosecution, and deposed that PW1 has deposed that he accompanied the PW3 and PW1 to the to the office of the petitioner, and based on the say of PW1, the tainted money was recovered at the instance of petitioner. Full stop. Thereafter, a mahazar was also, to that effect, a mahazar was also drawn by the local, by PW3, full stop. He also, PW3. The said version of PW2 corroborates to the evidence of PW3, the investigation officer, full stop. Moreover, moreover, PW2 has stated that the police have seized the documents,
The position of the
documents
petitioner.
from the possession of accused petitioner, from the
Also
possession of
granted money.
petitioner, in the office, That shows that shows the work
Work was
pending,
still-
that
yeah,
shows the
work was
pendence
still
of the
pending.
work with the
With the accused.
petitioner, full stop. He also contends that the proceedings in a contents that the scope of judicial review in a departmental proceedings is very limited as per the law laid down by this court and the Honorable Apex Court in pattern of judgments and the discipline and in the case on hand, the authority has proved the charges against the petitioner with the preponderance and probabilities, full stop. As such, the acquittal of the petitioner in criminal trial cannot be considered for any purpose, full stop. Any purpose, full stop. Accordingly, where another is Astelva,
One more. Here, the accused, the charge against the DGO is of unbecoming a government employee since he had not.
He also submits that since it could be concluded that based on the evidence of PW 123, it could be gathered that the petitioner demanded the illegal gratification from PW1 and also accepted the same since the said amount was seized in the office, in the drawer / office of the petitioner. As such,
From the custody of the DG.
Custody of the petitioner, as such, the charge against the petitioner that becoming an unbecoming of a government servant is proved, full stop. And the authority and the local, this inquiring authority rightly submitted the report, which does not call for any interference by this court, full stop. Accordingly, he prays to dismiss the writ petition. The learned government advocate, Tengalagi, also adopts the contentions raised by the learned counsel for the respondent number 2. Full stop. Having heard the learned counsel for the party, so also on perusal of the entire evidence and materials placed before us, the only point that would arise for our consideration is that whether the KSAT has justified in rejecting the application filed by the petitioner by confirming the order passed by the government.
Compulsory retirement.
That is the compulsory retirement of the petitioner, full stop. Next, we have careful on full stop. It could be seen from the records that before the inquiring authority, there are three witnesses. Three witnesses examined by the authority. Among them, PW1 is the complainant. Complainant, full stop. As stated, as discussed supra, though PW1 has lodged exhibit P1 before the Lokaयुcta police, before the inquiring authority, he has he has totally denied the contents of exhibit P1. Denied the contents of exhibit P1, full stop. Exhibit P1, full stop. Nevertheless, he has he has stated that he had not accompanied, he has stated that, the petitioner has neither demanded the illegal gratification from him nor accepted the same, According to him, according to him, the Lokayukta police, according to him, where is his evidence? Page number? Page number?
Please. Page number, in inquiry report, page,
Just
124.
the students are forced him, therefore he signed the
Ah,
complaint.
yes.
According to him, on the, according to him, on, what is the date of this one, raid?
No, date,
Date of raid?
25/8.
On 25/8/2012, he along with the PW 2 and 3, 2 and 3 went inside the 2 and 3 at about 4:15 PM. Went inside the DDPI office, full stop. The punch witness was support standing near the door, and he went standing near the door, and he went to meet DGO, that is the petitioner, full stop. When he inquired the petitioner, she informed that she has already completed work and asked to go
Outward section.
out, go out.
To outward section. To outward
Ward section, go to ward section, full stop. Thereafter, he asked to receive rupees 2,000, however, the petitioner refused to take. When he kept the money on the table, she pushed the money, and
It fell in the
pushed
drawer.
the money, and money fell into the drawer, full stop. Thereafter, the punch witness gave a signal to the police, and the police conducted the mazer.
Trap. Punch witness, shadow witness.
Shadow witness at the moment. Shadow witness gave a signal to the police. Though the said witness has been cross-examined by the counsel for the DGO, counsel for the cross-examined by the PO now.
First.
Cross-examined by GAA.
GA,
Independent
by
witness.
the authority, by the authority, she denied, he denied the suggestions made by the government advocate, suggestion made by the authority, full stop. On perusal of the evidence of this witness, it is clear that he has clearly narrated the incident that at no point of time the petitioner either demanded or accepted the illegal gratification, full stop. The other witness PW2 and PW2, another witness PW2 was the puncha for the trap proceedings. Though supported the case of the prosecution, he has categorically admitted that he was standing outside the office, and he came to know about the demand of illegal gratification only by PW1. Full stop. Even he entered the office of the petitioner after after the shadow witness,
Giving the signal.
after the shadow witness gave signal to him. However, as stated supra, the said shadow witness not examined in the DE proceedings, in the DE proceedings. Full stop. PW3 is the investigation officer also stated, reiterated the contents of PW, reiterated the evidence of PW2. PW2. In such circumstance, in such circumstance, there is no such evidence available on record to prove that the petitioner has demanded demanded or accepted the illegal gratification by the
From the complaint.
from the complainant PW from the complainant PW1 PW1 full stop. Though it is contended by the learned counsel for the Lokayukta that the amount was, the tainted money was recovered at the instance of the accused, that is from the drawer of the accused for the same, the PW1 himself has given an explanation, explanation as stated supra, full stop. Stated supra. Even otherwise, mere recovery of tainted money is not sufficient to prove the charges leveled against the accused, against the accused / petitioner. Full stop. The Honorable Apex Court in the case of CJappa, V. CJappa versus State by Police Inspector of Lokayukta Chitradurga, reported in 2016, volume 12 SCC 150.
Humble submission. I have a case in court on number.
ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ಎಲ್ಲ ಬಂದಿದೆ ಅಷ್ಟೇ ಅಲ್ವಾ? Para 21 as under. Para 21 as under. 21 as under. Full stop. Hence, hence it is clear that mere receipt of amount by the accused is not sufficient to fasten the guilt in absence of any evidence with regard to demand and acceptance of amount as illegal gratification, full stop. The illegal gratification, full stop. If the authorities fail to prove the demand and acceptance of illegal gratification by the delinquent, then, the charge against the delinquent, the unbecoming of a public servant cannot be sustained. Full stop. Cannot be sustained. Even sustained. Moreover, it is moreover, as rightly contended by the learned counsel for the petitioner, that the petitioner is acquitted in the criminal case initiated by the Lokayukta in special case number
6 of 30. Please.
Special case number
6 of 2013.
6 of 2013. In special case 2013 by the principal district and special Vijayapura, and they said acquittal judgment was confirmed by this court in criminal appeal number so and so, criminal appeal number so and so. In such circumstance, full stop, by this court, full stop. As could be seen from records, PW 1, 2, 3 were examined in the departmental proceedings, in the inquiry proceedings, were also the witness in the criminal case, in the criminal proceedings, who have examined as PW
1, 6 and 8.
6 and 8. PW 1, 6 and 8 respectively. 1, 6 and 8 respectively. Full stop. the similar evidence was deposed by them in the DE also, In such circumstance, the Honorable Apex Court in the case of Ramlal versus State of Rajasthan and others reported in 2024, volume 1 SEC 175 in page para 27, para 27 held as under. Para 27 held as under. Para 27 held as under. Held as under full show. In as under in such circumstance, in such circumstance, we can't accept the submission for submission of the learned counsel for the respond number to the Lokayukta that the authority has proved the charges leveled against the accused, the preponderance and probabilities, full stop. In that view of the matter, for the foregoing discussion, we are of the view that the tribunal has erred while rejecting the application filed by the petitioner by confirming the order of the order of the first respondent. In that view of the matter, we answer the point raised above in the negative, and proceed to pass the following order. Next, following order. The writ petition is allowed. The order of the petition succeeds. A writ of certiorari is issued. A writ of certiorari issued, quashing the order of the tribunal and the penalty order of dismissal.
Compulsory retirement.
Compulsory retirement from service. Full show. Consequently, the petitioner is entitled for all the benefit, all the service benefits under law. In light of setting aside the dismissal.
Reinstatement and all.
He is still service is there.
Yes, my lord, very much. And my lord, here, one more thing which I want to add, my lord, even my lord, tribunal prima facie, my lord, found that, my lord, that order was my lord, arbitrary, and there was an interim order of stay operating, my lord, throughout. And when I approached, my lord, this honorable court also, my lord, in the present petition, my lord, interim order is granted.
And she is working.
No. Interim order, it was not, my lord, interim order was not implemented.
Next, a writ of
Writ petition
writ petition in the tribunal it was operating. And here also, my lord, interim order was
working or not?
No, not now.
After filing the writ petition, he is submitting, my lord. From the date of WP, no interim order was continued, and she is not.
First respondent.
For during this period, no work, no salary.
No, my lord, because
otherwise it will be.
prima facie.
When did the
writ petition?
No, when did the compulsory retirement order come into effect? No, he is not working, isn't it?
My lord, throughout the proceedings before the tribunal, I had a benefit of interim order.
You have been paid, etc.
Yes.
For whatever work you have done. Now, the only order is pursuant to setting aside of that order. You will have to be reinstated.
Yes.
Consequential service benefits. That's all.
Consequently, consequential service and monetary benefits.
Reinstatement.
So, yes.
With consequential service benefits.
In view of the same, the petitioner is entitled for the first respondent is directed to reinstate the petitioner and also extend all the service benefits to it.
Service and monetary benefits.
Service and monetary benefits.
May make some clarification in this regard. My lord, the compulsory retirement order was passed on 24/11/2020, and the application was filed before the KAT. And there is an interim order. She continued. under the, my lord, interim order. Thereafter, writ petition is filed. The interim order was not continued. Only after filing the WP, only she is out of service, my lord. For that, no work, no salary. But otherwise, my lord, she has not worked after filing this writ petition in 2021. There are more than 3 years.
That's correct. So, now, till when she has worked, they have paid,
Yes, my lord.
isn't it?
Yes, my lord.
Correct. So now the order of compulsory retirement came into effect when? Till it came into effect just
When the interim
after the order of the
was not-
tribunal.
Yes,
my
my
lord,
lord.
No, after the interim order in these proceedings.
my lord,
It is not granted in this proceedings.
it is interim order is granted, my lord, in the
Then-
present petition.
Then you are working now.
No, my lord, they didn't, my lord, comply, implement model. That is the,
That's since when you are out of service?
yes, my lord. It is. It is in the, you know, the order sheet. my lord, kindly.
No, now, on the principle of no work, no pay,
Yes.
for the period that
She not worked.
employee has not worked.
Yes, my lord.
You
If
can-
it is
In the-
clarified.
My lord,
yeah,
I agree, my lord,
yes.
but in the instant case, my lord, in the present case, my lord, even my lord had interim, benefit of interim order before the tribunal, and this honorable court also, my lord, was prima facie, my lord, satisfied.
Maybe.
That is the reason, but my lord, their conduct, my lord, my lord, they could have, my lord, continued, my lord, me in the service. My lord, instead, my lord, I am not, my lord, reinstated, despite their big interim order. And I kept on moving the matter, my lord, so that, my lord, I can, so that once for all, my lord, the matter concludes.
Contempt ಆಗ್ತದೆ.
ಅವ್ರು ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ರು ತಾನೇ ಮಾಡ್ತಿದ್ರು.
My lord, contempt also filed, my lord, contempt was also filed.
Anyhow, what is the post? What is the post?
SDA,
DA,
second divisional assistant,
SD and DDPI office.
second divisional assistant.
I don't know what it means, but if they're comfortably placed, then
She is a lower divisional clerk, lower divisional clerk,
SDA.
SDA, lower divisional clerk,
SDA.
SDA.
LD ಅಂತಿರಲ್ಲ.
ಅಂದ್ರೆ ಕೆಲವೊಂದ್ ಕಡೆ LDA ಅಂತಾರೆ.
What is how much time you are out of service?
My lord, since from the filing of the present writ petition, my lord,
How many years?
and it's been, my lord, from September 2000, my lord, 21. From September 2021.
21 till date.
Till?
Till date, my lord. She is out.
Till date, my lord, I am out of service.
Therefore, this
Interim
period, my
order,
lord,
just interim order was in place for the entire period.
Interim order is there, my lord. Interim order is there. And what had happened, my lord?
Just one. Interim order is passed on 29/11.
Yes.
Isn't it?
Yes.
29/11/2021.
Yes.
There's an interim order which is in force till today.
Yes.
So
And-
you are saying just one.
Please.
You are saying for this period, something must be done.
Yes. And back page, my lord,
Not full back, how we can give? You have not worked.
because, my lord, one thing, my lord, which I would like to submit, my lord,
even
on the guys, my lord, that I was relieved, on the guys, my lord, that I was relieved. I was not reinstated despite there being an interim order. And, my lord, only because, my lord, this honorable court, but there is no, my lord, my lord,
No, correct. So now, the only point is there's an interim order admittedly between 29/11/21 till date. So we could set it up.
continuity of service, my lord, may be given for no work, no salary. She has not worked, no salary. The tenure may be, my lord, taken into
So
consideration
that even
for
if-
other benefits.
Correct. Suppose reinstatement, if order, even otherwise we would have given continuity in service. But because the interim order, some amount you will have to pay. You should have restored. Why you did not reinstate once the interim order is there? So 25% of the salary you pay. Don't insist anything more than that.
My lord, in the normal course, my lord, the court would decide, my lord, but in the instant case, my lord, since I had the benefit, my lord, on both these occasions, my lord, my lord, request, my lord, that the any, my lord, like something has to be extended to.
So continuity in service will follow,
Yes, ma'am.
isn't it? Apart from that, 25% of the wages.
Because of interim order, it was not over
Of
for
the
that
salary.
reason.
Because, my lord, she's been, my lord, without employment since from the last, my lord, more than 3 years or no. And it would be, my lord,
My submission may be recorded, my lord, no work, no salary, and the honorable court can pass.
On the on a point on a query to the learned counsel for the petitioner, it submit that though the interim order was operating ever since from the day from
29 September 29.
persons from 29/11/2021, the authority, they have failed to reinstate the petitioner, right to reinstate the petitioner. Forward, in such circumstance, we deem it appropriate to in such circumstance, on the such circumstance, on the principle of by applying the principle of wait, what? Full stop. Per contra, the learned government advocate, government advocate.
I submit that, my lord, she has not worked, no salary.
Since the the petition is not entitled for the period which she has not worked on the principle of no work,
No
no
salary.
salary, no
Please.
sir, no pay, full stop. However, in the peculiar fact and circumstance of the case, we are of the view that the fact of the case, we direct the authority to pay 25% of the salary for the period which she
Out of
for the
service.
period
From
50,
from
at least
29
11,
11/2021
till
till
date.
Reinstate.
at least 50%. Even in cases of suspension, order 50% subsistence is paid. And
Suspension irutte.
but here, otherwise, yes, my lord, I will grateful. But my lord, in the normal course, my lord, I wouldn't have, my lord, pressed. But this is a case.
Now you got the job.
The truth is somewhere in between. Truth is somewhere in between.
Great.
Girish Patil?
May I submit, my lords?
Yes.
My lords, yes, just one submission, my lord. If my lords are not appreciated with my arguments, my lord, then I'll argue just another 2 points on acquittal, or rather on 304 part 2, my lords.
Acquittal, you don't argue. We are convinced. Now you say your other argument. Come directly to the point. Come directly to the point. Yes.
Yes, my lord. My lord, 2 points. Number 1, it is undisputedly true that, my lord, 4 material objects have been seized from the scene of crime. And PW13, who happens to be the sole IO who have conducted 80% of the investigation, has agreed admittedly in full knowledge that he has seized 4 articles, that is Memo 124, from the scene of crime in his cross-examination. First one being that the 5-liter kerosene can. Number 2 being the chimney lamp. Number
Counsel,
3 being the...
Correct. Now, counsel, insofar as acquittal, we are not with you. We have made up our mind. We have heard you.
Yes, ma'am.
Now, on your other argument of sentence and what you are mentioning, you say, let us see if you can make out a case. That it
Yes,
doesn't
yes.
come. Yes.
Yes, ma'am. So when these 4 objects are being seized from the scene of crime, the very important principle is that what has committed the crime, or which object is used for committing the crime, that is undisputedly, as stated by the deceased herself, that is the chimney lamp, my lord. In the exhibit P8, as I pointed out yesterday, my lord. Exhibit P8 ಅಲ್ಲಿ chimney lamp, chimney bottle ಇಂದ ಅಂತ ಹೇಳ್ತಾಳೆ. So when this is a statement, what prevented the IO to send that chimney bottle, which is of glass, as admitted by PW13, to the FSL, and non-examination of that chimney bottle, which is used perfectly for committing the crime, that is, in other words, which is used by the appellant, which is used by the accused herein for pouring kerosene. Now, my question to this honorable court is that, who knows what was there in that bottle? Now, I may say that bottle might contain water also, because FSL report is not there, and it is their duty. They have caused a mistake because they have exhibited the document, and the judge has told that it is a Xerox document also. It is not an original document. Now, leaving that apart, my lord, what the bottle contains, even today we don't know. Now, when such being the fact, when she says that kerosene is being poured on me and I was being ignited fire, what is there in that bottle? That is $1 million question. So when there is a link which has not been established, then, my lord, according to this thing, my lord, the crime has not been established only. So the basic 2 principles of criminal law, that is, the act has been done and the act has been done by the accused. No doubt act has been done, but whether the act has been done by the accused, that is left unanswered even today. This is my argument. And, my lord, I may take my lords, and even on dying declaration also, the fitness certificate is not there, my lord. He says, I have taken the, sorry, if my lords go into this thing, PW13, my lord, if my lords, please, my lord, PW13.
No, correct. Now, if acquittal case is not made out, what is your second argument as an advocate for the accused?
Then it is, yes, my lord. Then it falls under 304 part 2, my lords.
You can't simply say that. You have to make out a case for that. That's what we are saying. We can't lead you to that.
Yes, my lord. I apologize for that, my lord. Now, the thing is, my lord, on 304 part 2, I have produced one judgment, which is of, now all judgments are of the Supreme Court only, wherein, my lord, the deceased had sustained 98% of the injuries, burn injuries, which was being caused by the appellant, and he had poured the kerosene on her, and she has sustained 98% injuries. And thereafter, my lord, in the judgment of Last but second judgment, my lord, Dattatreya Gavli versus State of Maharashtra. It is the sixth judgment, my lord. Sixth judgment.
Now, which paragraph?
Yes, my lord. I'll just go through that. My lord, in this, she had sustained Dattatreya Gavli was a state of Maharashtra. In this case, my lord, the appellant was married with the deceased, my lord, and also she was astonishingly she was 9 months pregnant, and also as per the facts, my lord, he was also addicted to drinking, and on an unfaithful day, he was on 26 January 2007, my lord, he had poured kerosene on her body, and due to which she has sustained 98% burn injuries, my lord. It is there in the first paragraph. It is there in the first page, second paragraph, my lord. The last 3 lines. The wife sustained burn injuries, which in hospital were determined as 98%. She was taken to civil.
Read from para 20.
Yes. From every available evidence which was placed by the prosecution. May I read, my lords?
Yes.
From every available evidence which was placed by the prosecution, it is a case where sudden fight took place between the husband and wife. The deceased at that time was carrying a pregnancy of 9 months, and it was the act of pouring kerosene of the deceased that resulted in the fire and subsequent burn injuries and the ultimate death of the deceased. In our considered opinion, this act at the hands of the appellant will be covered under 4th exception given under section 300 of IPC. That is, culpable homicide is not murder if it is committed without premeditation in a sudden fight in the heat of passion upon a sudden quarrel and without the offenders having taken undue advantage or acted in a cruel or unusual manner. The act of the appellant is not premeditated but is a result of sudden fight and quarrel in the heat of passion. Therefore, we convert the findings of section 302 to that of 304 part 2 as we are of the opinion that though the appellant had knowledge that such an act can result in the death of the deceased, but there was no intention to kill the deceased. Therefore, this is an offense which would come under part 2, not under part 1 of section 304 of the IPC. May I continue, my lords?
Yes.
On similar facts as are present in the case at hand, this court had converted the findings of section 302 to that of section 304 part 2 IPC. The case of which reference is being made here is Kalaburagi versus State of Rajasthan. The appellant who had been convicted in section 302 IPC for causing death of his wife by pouring kerosene on her and then setting her on fire was convicted by the trial court under section 302, which was upheld by the High Court. The facts of the case are as follows. May I read the whole paragraph? In the above case, the appellant who in an inebriated state was pressurizing his wife to part with some ornament so that he could buy some more liquor. On her refusal, he poured kerosene on her and set her on fire by lighting a matchstick. But then he also tried to pour water on her to save her. This court was thus of the opinion that very probably he would not have anticipated that the act done by him would have escalated to such a proportion that she might die. If he had ever intended her to die, he would never altered his senses to bring water in an effort to rescue her. We are inclined to think that all that the accused thought of was to inflict burns to her and to frighten her. But unfortunately, the situation slipped out of his control and it went to the fatal extent. He would not have intended to inflict the injuries which she sustained on account of his act. Therefore, we are persuaded to bring down the offense from first degree of murder to culpable homicide not amounting to murder. We therefore alter the conviction from section 302 IPC to section 304 part 2 IPC. The facts of the present case, as we have already discussed above, by and large reflect the same situation, nature of crime as well as the act of the accused and the consequence of his action. We are inclined to accept the arguments raised by the learned senior counsel for the appellant, Mr. Sudhanshu so-and-so, that under the present circumstances, it would indeed be a case of culpable homicide not amounting to murder, as given in section 304 part 2, in as much as though the accused had knowledge of the consequence of the act he was committing, yet there was no intention to cause death. The appeal is partly allowed. We convert the findings of the section 302 to that of section 304 part 2 of IPC and sentence the accused to 10 years of rigorous imprisonment. To this extent, the findings given by the trial court and high court will stand modified. We have also been informed that the appellant has already undergone incarceration for more than 10 years. Therefore, he shall be released forthwith from the jail unless he is required in some other offense. Just one more submission, my lord. In another landmark judgment, my lord, that is fourth judgment, my lord, State of Rajasthan versus Wakteng, my lords. In this judgment, my lord, very interestingly, this case is all about the concept of admissibility of dying declaration in the absence of witness certificate as issued by the doctor, my lords.
ನಿಮ್ದೇನು ಇಲ್ಲಲ್ಲ SPP ಅಷ್ಟೇ ಅಲ್ವಾ? ನಿಮ್ದೇನಾದ್ರೂ ಇದೆಯಾ ಇಲ್ಲಲ್ಲ?
Minutes, what he has, my learned friend has submitted while reading this, that the page number 11 in third citation, in the above case, the appellant who in an inebriated state was pressurizing his wife to part with some ornaments so that he could buy some more liquor. On her refusal, he poured kerosene on her and set her on fire by lighting a matchstick. But then he also tried to pour water on her to save her. Here there is no save. Even she could have been shifted to the hospital. He didn't try for that.
That shows he's not cruelly, in a cruel manner, not behaved in a cruel manner. In that case, not
Yes, ma'am.
behaved in a cruel manner.
Yes, ma'am. There was no intention. And to attract the section 304 part 2, man, sudden introduction, that question does not arise, man. Since 3 years, he has been crueling her.
Exception 1, now you just go through exception 1
Well,
to 300. There is a difference between exception 1 and exception 4.
4, yes.
So exception 1 says, in a grave and sudden provocation, just read exception 1, C1, exception 1.
Yes.
Exception
May I
4
read
in a
the-
sudden, in a sudden fight.
Yes.
Exception 4 in a sudden fight, premeditation, that is a different, and cruel manner, that is exception 4. Exception 1, just go through exception.
When
1.
culpable homicide is not murder.
Huh.
Yes. Culpable homicide is not murder if the offender
Huh.
was deprived of the power of self-control by grave and sudden provocation.
Hmm.
Causes the death of the person who gave the provocation or causes the death of any other person by mistake or accident.
Causes the death, say, in this list deprived of his self-control due to a provocation. So we can say she has given some provocation. The deceased has given some provocation. In
Madam,
that row, she has given some provocation. And thereafter, he all of a sudden he did. And has not poured the kerosene to her entire body. Has poured the she survived for another 18 days.
Of course, my lords, the question would be, my lords, anyhow, he had an intention to kill her. Because of that, he poured kerosene.
That cannot be ಅಂತ. ಇಡೀ ಬಾಡಿಗೆ ಸೀಮೆಯನ್ನು ಹಾಕಿ ಏನೋ ಮಾಡ್ತಾ
That-
ಇದ್ರೆ
That can be interpreted in both the way, my lords. My lords.
ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ he lost.
he lost self-control.
Because she said she won't give. No doubt that's the correct stand. But at that moment, suddenly he lost his, when she said she will not part with money.
For the exhibit P8, my lord, she has narrated pertains to that aspect since it's, as she was being cruelly,
That's the reason a pattern of judgments in, on this 300. So there's a thin layer.
yes, I do agree.
Difference,
I
thin
do
layer. 300, 302, okay.
I do
The
agree.
fight of husband and wife will go on in perpetuity. She will always ask, he will always say no.
Yes.
At some point, something appears to have happened subsequently.
Yes.
Yes. Perfect. This appeal by the convicted accused directed against the judgment of conviction and order of sentence dated 21/8/2021 passed in SC number 102 of 2016 by the additional district and sessions judge at Bidar, wherein the learned session judge convicted the accused Lashapalin for the offense punishable under section 498A, 302 of IPC and sentenced him to undergo simple imprisonment for a period of 1 year, for the offense punishable under section 498A of IPC and shall also pay a fine of rupees 1,000 and in default of fine, payment of fine, SI for simple imprisonment for 1 month. The accused also sentenced to undergo imprisonment for life, bracket ali, reminder life of the accused, bracket close, for the offense punishable under section 302 of IPC and shall pay fine of rupees 5,000. Full stop. It is further directed that both the substantive sentence, both the substantive sentence shall run concurrently, full stop. The abridged facts of the prosecution case are that the deceased in this case, Mukta, is
Alias Bhagirathi.
Mukta alias Bhagirathi is the wife of accused, full stop. Their marriage was solemnized 6 months prior to 2/9/2015. 2/9/2015. That is the date of incident. Full stop. It is alleged, full stop. Full stop. After the marriage, the deceased, after the marriage, the appellant accused used to harass, ill-treat the deceased both physically and mentally, full stop. 2 months after the marriage, the accused started consuming alcohol and used to harass her and used to assault her without any reason, full stop. On this backdrop, so on 2/9/2015 at about 7 p.m. 2/9/2015 at about 7 p.m. The accused came drunk. Accused came drunk to the house and abused the deceased in a filthy language. And when she replied that if he regularly did not pay any amount, it is difficult her to run the family, enraged by the said advice and objection to his alcohol addiction, the accused again abused her and proclaimed that he will finish her, full stop, finish her. By saying so, the accused poured kerosene on her person and her person and set her ablaze with the help of a chimney lamp. Full stop. When she cried for help, comma, her mother-in-law, PW 5, 5 or
5.
PW 4.
PW 4 is the deceased mother-in-law.
Deceased,
yes,
correct.
yes,
PW 4.
PW.
PW 4 came to her rescue. Full stop. The accused fled away. At that time, the accused fled away from the spot. Full stop. Subsequently, the deceased Mukta telephoned her brother-in-law, PW 7, and informed about the incident. Full stop. PW 7 rushed to the spot and shifted her to the hospital in an ambulance. Full stop. She was full stop. Accordingly, she was admitted at admitted as an inpatient in government hospital Balki, and was treated by PW
10.
PW 10, the doctor. Full stop. Then died. On the next day, that is on 3/9. Next day, 2015, 3/9/2015, the PW based on the MLC, PW 13, the PSI of the respondent police proceeded to the government hospital and recorded the statement of the injured Mukta. Full stop. On the strength of the said statement, has registered the case against the accused for the offence punishable under section 498A and 307 of IPC in crime number 193 of 2015, dated 2/9/2015, for the offence punishable under section 498A and 307 of IPC. Full stop. Subsequently, after 2 days, the injured Mukta was shifted to Latur, Maharashtra for higher treatment.
One submission, my lords. The case has been registered on 2/9/2015 at 9:45 PM on the same date.
3/9 anta beda.
3/9.
2/9 antle mele. On the same day anta
On the same day.
Same day.
At 9:45.
Next day, same day anta last. And I think Latur for higher treatment, and she survived there for a period of 18 days, and succumbed to the injuries on 21/9/2015. 21/9/2015. Full stop. Accordingly, based on the death report of the deceased, or death report of the said Mukta, the investigation officer submitted a requisition before the jurisdictional magistrate to invoke section 302 of IPC, and the permission was granted by the magistrate, and accordingly section 302 of IPC was invoked in crime number 193 of 2015. Full stop. Thereafter, the investigation officer, conducted the investigation by drawing the relevant mahazars like the spot panchanama and panchanama by seized the Memo, seized the Memo 1 to Memo 1 and 2, and also conducted the inquest panchanama on the dead body, on the corpus of the deceased, and after recording the statement of the witnesses, laid the charge sheet before the committal court
Emo
before the
1 to 4.
committal court.
Emo 1 to 4.
ಅಲ್ಲ 4 and 4 ಅವಳ ಡ್ರೆಸ್ ಅಲ್ವಾ ಮತ್ತೆ subsequent.
ಹೌದು.
ಏನಂದ್ರೆ before the committal court,
Yes.
before the
Yes.
committal court for the aforementioned offenses, full stop. Next, after committal of the case before the session court, the learned session judge framed the charges against the accused for the said offenses and read over to the accused, which was denied by the accused and he claimed to be tried. Full stop. Next, in order to prove the charges leveled against the accused, the prosecution has examined in total 14 witnesses as PW1 to PW14. So also got marked 16 documents as exhibit P1 to P16 and identified 4 material objects MO1 to 4. MO1 to 4. Full stop. The 1 to 4. After completion of the prosecution evidence, the learned session judge read over the incriminating portion of the evidence of the material witness to the accused as contemplated under the provision of section 313 of CRPC, which was denied by the accused. Full stop. The defense of the accused is of false implication, is of total denial and that of false implication. Full stop. However, the accused neither examined any witness on his behalf nor got marked any documents. Full stop. Next, after assessment of the oral and post-assessment of the oral and documentary evidence placed by the prosecution, the learned session judge convicted the accused for the charges leveled against him and sentenced him as stated supra. Full stop. The said judgment is challenged under this appeal. Full stop. We have heard, next one. We have heard the learned counsel, Shri so and so Patil for the Mahesh Patil. Girish Patil for the appellant. So also the Shri Siddhalinga Patil. Shri Siddhalinga Patil for the state, respondent state. For the respondent state. The primary contention of the learned counsel for the appellant that, the learned session judge totally erred while convicting the accused for the charges leveled against him without appreciating the evidence in a right perspective. Full stop. He would further contend that the learned session judge has convicted the accused only based on exhibit P8, that is the statement said to have been made by the deceased before PW13, the PSI in the hospital. Full stop. Hospital. In the hospital. According to the in the hospital. However, there is no such evidence forthcoming on record that the injured was in a fit condition to make such statement before PW13. The author of the said statement, that is PW13, failed to obtain the necessary certificate, failed to obtain the fitness certificate from the duty doctor before recording the said statement. Full stop. Hence, according to the learned counsel, much evidentiary value cannot be attached to exhibit P8. Full stop. He would further contend that the evidence of PW5 and PW full stop. He would further contend that the PW our mother-in-law fourth PW4, the eyewitness to the PW4 eyewitness to the incident totally turned hostile to the prosecution case. prosecution case, full show. In such a circumstance, prosecution case, full show. Though the prosecution relied the evidence of PW5 and PW5 and PW5 to 8, PW5 to 8, comma, among them PW5 and 6 are the hearsay witness, PW5, 6 and 8. PW5, 6 and 8 are the hearsay witness, comma, according to them, they came to know about the incident through PW7, who shifted the injury to the hospital, as a full show, Even otherwise, according to PW7 also, he reached the spot after the incident, and he shifted the injured to the hospital in a ambulance. Except the same, comma, he also not aware about the incident, full show. In such circumstance, comma, their evidence cannot be considered to prove the charges leveled against the accused, full show. He would, but the learned counsel would further contend that there is a serious discrepancies in the evidence of PW3, PW4, PW5, 6, 7, and 8, PW5 to 8, PW5 to 8, PW5 to 8, in respect of the alleged harassment meted out by the accused before to the deceased before the incident, full show. They would also contend that according to Exhibit P8, the complaint lodged by a complaint, comma, the accused, comma, poured the kerosene on the person of the deceased, which was kept in a bottle, However, the prosecution has sent a plastic can. Prosecution has seized a plastic can from the spot, and the same was sent for FSL. In such circumstance, comma, there is a doubt creates in the genesis of the crime, full show. The learned counsel also submits that the prosecutor submits that the respondent police failed to make any attempt to record the statement of the victim injured in the hospital where she was admitted for higher treatment at Latur, though she survived for a period of 18 days. In such circumstance, comma, the prosecution case cannot be believable. Accordingly, he prays to allow the appeal. Full stop. Accordingly, he also contend that the learned session judge totally erred by sentencing the accused for his remainder life, though such power is not vested with the session court as laid down by the Honorable Apex Court. Full stop. Accordingly, he prays to allow the appeal by setting aside the impugned judgment. Full stop. Alternatively, he contended that even if admitting the entire evidence placed by the prosecution on the face of it, comma, this case squarely falls within the ambit of section 3, exception 1 to section 300 of IPC, which is punishable under section 304 part 1 of IPC. Yes, full stop. Part 1 of IPC. Since the entire incident is caused in a spur of moment, in a grave and sudden provocation by losing the self control of the accused in the row in the family in the row erupted at in the house between the accused and deceased were the husband and wife. Husband and wife. Full stop. To buttress his argument, he relied the following judgments. Memo ಹಾಕಿ ಕೊಟ್ಟಿದ್ದಾರೆ judgment 1, 2, 3 ಹಾಕೊಟ್ಟು the following judgment and 1, 2, 3 ಅಂತ. Refuting the above submission of the learned counsel for the appellant, Shri Patil, the learned additional SPP, would submit that the judgment does not suffer from any perversity or illegality, since the learned session judge has convicted the accused after meticulously examining the evidence available on record in a well-reasoned judgment which does not call for any interference. Full stop. He would contend that the prosecution has placed sufficient material to prove the charges leveled against the accused. Full stop. The exhibit P8 complaint lodged by the complaint given by the deceased herself in the hospital immediately after the incident, or soon after the incident, before PW13, and the contents of exhibit P18 clearly corroborates with the evidence of PW528. Full stop. PW528. Moreover, the evidence of PW7, who was the brother-in-law of the deceased, deceased, clearly reveals that on the date of incident, after the incident, the deceased, the injured called him through mobile phone and he informed that the accused set her ablaze. Accordingly, he rushed to the house of the deceased and there she clearly narrated the incident once again, and thereafter he shifted her to the government hospital at Balki. Full stop. Balki. Full stop. Thereafter, her statement was recorded by the PW13. Full stop. Nevertheless, the parents of the deceased, PW4, 5 and 6, have clearly stated that the accused after marrying the deceased Mukta, used to ill-treat her both physically and mentally, by demanding money from her for his bad vices. Full stop. In such circumstance, bad vices. Full stop. Full stop. Full stop. Full stop. According to the learned SPP, the injured was survived for a period of 18 days after recording of exhibit P8. In such circumstance, it cannot be said that the injured was not in a fit condition to give statement as per exhibit P8. Full stop. He would contend that the minor contradictions in the evidence of material witnessed does not go to the root of the prosecution case. Hence, according to him, the session judge has rightly convicted the accused and accordingly he prays to dismiss the appeal. Next. Having heard the learned counsel for the respective parties, so also having perused the entire evidence and the documents placed before us, the point that would arise for our consideration are: 1, whether the judgment under this appeal suffers from perversity and illegality. Number 2, whether the learned session judge is justified in convicting the accused for the offense punishable under section 302 and 302 and 498A of IPC. IPC. Full stop. IPC. Question mark. Full stop. As a full stop. Next, as could be seen from the records, comma, though the prosecution has examined in total, comma, 14 witnesses in this case, comma, we are of the view that there is no necessity of examining the evidence of all the witnesses. Suffice to discuss the evidence of the material witness relied by the prosecution to prove the guilt of the accused.
Even my lords, the yesterday my lords have asked me the evidence value, that is section 45. As per the expert.
Full stop. Next, in order to prove the homicidal death of the deceased Mukta in this case, comma, the prosecution has relied on the evidence of relied on exhibit P13, the postmortem report placed by the prosecution. So also the evidence of doctor who initially treated the injured, that is PW10, and the case sheet exhibit P6. Full stop. On perusal of exhibit P13, the postmortem report marked in the evidence of PW14, the IO, comma, the cause of death stated that death is due to septicemia, say shock due to burn injuries. Full stop. On burn injuries, on perusal of exhibit P6, the case sheet placed by PW10, the doctor, also depicts that the deceased sustained burn injuries to about 35%, on a person. Full stop. The prosecution also relied the inquest Panchanama drawn on the corpus of the deceased as per exhibit P5 by PW12, the investigation officer. Full stop. PW7 is the witness for the same. Both PW7 and PW12 were identified the burn injuries on the corpus of the deceased. Full stop. Full stop. Nevertheless, the prosecution also placed exhibit P15, the case sheet of deceased maintained by the hospital at Latur, while at Latur. Full stop. On perusal of exhibit P15 also, comma, the same reveals that the deceased was treated for the burn injuries for a period of 18 days, and thereafter she succumbed due to septicemia. Full stop. In such circumstance, comma, we are of the consider view that the prosecution has proved the homicidal death of the deceased in this case due to burn injuries. Full stop. Next, the next part. To connect the accused for the homicidal death of the deceased, comma, the prosecution mainly relied on the relied on exhibit P18, the oral dying declaration, the dying declaration made by the deceased soon after the incident. That is on
7/9.
7/1.
Sorry, my lord, 2/9. 2/9.
That is on 2/9, sorry, 2/9/2015. 2/9/2015. 2/9/2015. Full shot. 2015. Which was recorded by PW12, PW13, sorry,
13.
PW13 in the government hospital at
Balki.
At Balki. Full show. On careful perusal of exhibit P18, the deceased stated that after her marriage with the accused, he was addicted for the bad vices and used to consume liquor on daily basis and used to quarrel with her by demanding money. Full show. On 2/9/2015 at about 7 p.m., he came to the house by consuming alcohol and thereafter picked up a row with her and abused her in filthy language. When she advised him not to indulge in such act, he all of a sudden he took the kerosene bottle from the house and poured kerosene on her person and set her ablaze with the help of chimney lamp. Thereby she sustained injuries and the said incident was witnessed by PW4, that is her mother-in-law, who is the mother of accused. Subsequent mother of accused. Full stop. Later she called PW7, her brother-in-law, through mobile phone and informed him about the incident. He visited the house and shifted her to government hospital and admitted her. Got admitted her. Full stop. They said statement. Full stop. Though they said statement admitted her. They full stop. Though the said statement of the deceased was recorded by PW13 without obtaining any necessary document, without obtaining the fitness certificate from their duty doctor. Nevertheless, PW13 has deposed that she was very much conscious while giving such statement, while narrating the incident, or while giving such statement by narrating the incident. Full stop. Narrating the incident. Further, it could be seen from records that the deceased was sustained only 35% of burn injuries at that point of time. And she was conscious.
And also he has taken permission from the doctor.
She was conscious. Conscious. It is pertinent to mention that at this juncture, the evidence of PW13 reveals that he took the permission from the duty doctor to record exhibit P8. Full stop. Exhibit P8. Exhibit P8. Next. P8. Further, the contents of exhibit P8, clearly corroborates to the evidence of PW7, who shifted the injured to the hospital. According to him, before shifting her, according to him, immediately after the incident, he visited the house and the injured informed him about the act committed by the accused. Thereafter, he shifted her in a ambulance to the hospital, full stop. The hospital. Nevertheless, full stop. Nevertheless, PW5, PW5, sorry, for Allah. PW5, PW6, and PW8, that is PW8, were also visited the hospital on the on the same day in the late night. At about 1 p.m. 1 p.m. All these witness on AM. All these witnesses have categorically deposed before the deposed in their evidence that that in the hospital the deceased informed them that they informed them about the harassment meted out by the accused and also about the incident on 7/1 and on 2/9/2015. 2/9/2015. Full stop. The deceased was very much conscious at that point of time, and she narrated the incident. Narrated the incident that the accused poured kerosene on her and set her ablaze. Full stop. Set her ablaze. Full stop. Moreover, PW4, 5, PW5, 6, 7, and 8 have also deposed about deposed that ever since from the date of marriage, the deceased, the accused used to ill-treat her both physically and mentally by demanding money from her for his bad vices. Full stop. Bad vice. Full stop. Bad vice. Full stop. It is full stop. It is vehemently argued by the learned counsel for the appellant that the prosecution has failed to obtain. The prosecution has failed to place any material evidence to show that the victim was conscious. Victim was in a fit mental state of condition to give the statement exhibit P8, and also to make oral statement before PW 5, 6, and 8. 5, 6, and 8. Full stop. 5, 6, and 8. How 6 and 8?
Even 5, 6, 7, and 8.
PW 5 to 8 and that. PW 5 to 8. Full 5 to 8. The 5 to 8. Full stop. It is the full stop. 8. As discussed supra, immediately after soon after the incident, the injured was shifted to the hospital by PW 7. And the disease, she was sustained only 35% of burn injuries at that point of time. Full stop. On perusal of the evidence of PW 13, the scribe of exhibit P18, he has clearly stated that the injured was conscious at the time of giving the statement. And he also obtained permission from the doctor to record such statement. Full stop. The record such statement. Admittedly, the deceased was succumbed to the injuries after 18 days from the date of incident. Full stop. We are aware the fact that in the dying declaration, while the conviction is, if a conviction is based on dying declaration of the deceased, the same has to be appreciated in due due care, full stop. It is the full stop. The juristic theory regarding acceptability of a dying declaration is that such a dying declaration is made in extremity, comma, when the party is at the point of death and when every hope of this world is gone, comma, when every motive to falsehood is silenced, comma, and the man is induced by the most powerful consideration to speak only the truth, full stop. Notwithstanding the same, great caution must be exercised considering the weightage to be given to such declarations, full stop. The Honorable Apex Court in the case of Lakshman versus State of Maharashtra, reported in 2002, volume 6 SCC 710, held at para number 7, as under. Para number 7, as under. Full stop. As under. On perusal of the findings of the Honorable Apex Court in the above judgment, a certification by the doctor while recording the statement of injured is essentially a rule of caution, and therefore the voluntary and truthful nature of the declaration can be established otherwise, full stop, can be established otherwise, full stop. Moreover, there is no such hard and fast rule that while recording the statement of the deceased, the statement of a declaration of the deceased injured, comma, the said statement must be recorded by the magistrate or the tahsildar, and the doctor must be present at the place of at that time, full stop. At that time. In the case on hand, comma, as stated supra, the statement of the injured was recorded soon after the incident, comma, soon after the incident, and there is no such chance of tutoring the injured by any of the witnesses, or by the police, any of the witnesses or by the police, full stop, by the police. Point has to be the only aspect has to be considered is has to be beginning to consider that whether the injured was conscious at the time of making such declaration. In the case on hand, comma, we are of the case on hand by perusal of the entire evidence, by perusal of the contents of Exhibit P8, comma, the evidence of PW 13, so also the evidence of PW 5 to 8, we are of the view that
Exhibit P15 also, sir, case.
And also the Exhibit P15, the case sheets.
Yes.
Case sheets maintained by the hospital authority till the death of the injured, comma, we are of the view that the injured was conscious at the time of making the declaration. Exhibit P8. So also Exhibit P8, full stop. P8. Further, the evidence of PW 5 to 8, PW 8 to 5 to 8 also also substantiate the contents of Exhibit P8. All these witnesses were categorically stated that they visited the hospital on the date of incident itself. incident itself at about 1 a.m. That is in the late night, 1 a.m. and the injured informed them about the act committed by the accused, full stop, by the accused, full stop. In such circumstance, comma, we are of the view that full stop, in such circumstance, Mudulaki, full stop. Though the defense has cross-examined these witnesses at length, comma, nothing worthwhile has been elicited from them to discard their testimony, full stop. Even otherwise, the defense has failed to put forward any defense to prove that these witnesses have falsely deposed the reason for false implication of the accused, who being the husband of the deceased, full stop, full stop. As stated, full stop. Full stop. The prosecution, full stop. Admittedly, the incident caused in the house of the accused, accused and deceased, full stop. The accused and deceased. The accused is duty bound to explain the reason for the death of the homicidal death, reason for the homicidal death of the deceased in the house, full stop, in the house, as contemplated, since the said aspect is only within the special knowledge of him, within his special knowledge, full stop. His special knowledge as contemplated under section 106 of the Indian Evidence Act, full stop. If the accused failed to discharge, failed to rebut such presumption, accused failed to give any such explanation, then comma, the court can draw a presumption against the accused as contemplated under section, as per the provision under section, as per the provision of section 114 of Indian Evidence Act, 114 of Indian Evidence Act, full stop, Evidence Act, full stop. In the case on hand, the defense of the accused that the deceased had an illicit affair with the PW7, who is none other than the brother-in-law of the deceased, and as such brother-in-law of the deceased, and the said aspect, and on the date of incident, the said aspect was revealed. As such, she committed suicide. Herself by pouring kerosene and setting her ablaze. The kerosene ablaze, full stop. To substantiate, to prove the said defense, comma, admittedly the accused failed to, they admit that the accused has neither examined any of the witness nor got marked neither examined any witness, full stop, any witness. Nevertheless, PW8 being the wife of PW7, PW7 categorically denied such suggestion made by the accused, full stop. We are of the full stop. On perusal of the evidence of PW4 to PW5 to 8, comma, we are of the considered view that the defense of the accused is not a probable one. As such, he failed to explain the circumstance of the homicidal death of the deceased on the fateful day. As such, adverse inference can be drawn. As such, presumption can be drawn against him. as per the section 114 of Indian Evidence Act. Full stop. Indian Evidence Act. Full stop. Full stop. It is the contention of the learned counsel for the counsel for the accused that the eyewitness PW4 totally turned hostile. Full stop. Hostile. On perusal of her evidence, she being the mother of accused, in order to being the mother of accused, mother of the accused, due to the relationship, due to the said relationship, she turned hostile. She might have turned hostile to the prosecution case. Prosecution, that itself is not a ground to discard the evidence of the other material witness PW4 to PW8. Full stop. The PW48. The minor contradictions in the evidence of evidence of the material witness, material witness does not go to the root of the prosecution, prosecution case, prosecution case, in the prosecution case. Full stop. The Honorable Apex Court, in the case of Apex Court, in the case of Revan, held that the minor contradictions in the evidence of material witness cannot be termed as itself is not a ground to discard their testimony. Full stop. Discard their testimony. Full stop. Further, judgment citations. Citation ಮೇಡಮ್ ಅದು ರೇವಣ್ಣ ಸಿದ್ದಪ್ಪ ಅಲ್ಲ, ಇಲ್ಲ ಇದು ಅದು ರೇವಣ್ಣ ಸಿದ್ದಪ್ಪ ಅಲ್ಲ, ಅದು Mallikarjun and others, State of Karnataka, reported in 2019, volume 8, SCC 359. The Honorable Apex Court held that while appreciating the evidence of material witness, the approach must be assessed whether the evidence of witness read as a whole appears to be truthful. Full stop. Once the impression is formed, it is necessary for the court to evaluate the evidence and the alleged discrepancy, and then to find out whether it is against the general tenor of the prosecution case. Full stop. If the evidence of witness is found to be credible and trustworthy, minor discrepancies which do not affect the core of the prosecution case cannot be made a ground to doubt the trustworthiness of the witness. Full stop. It is witness. Witness. Full stop. Further, though it is contended by the learned counsel that the PW5 to 8 are the close relatives of the witness, and they are the partition witness to the prosecution case, their evidence cannot be relied to convict the accused. However, the Honorable Apex Court in the case of Revanna Sahib Gode alias Revanna Sahib versus State of Karnataka, reported in 2023, volume 5, SCC 391, held at para 17 as under. 17 as under. Full stop. as per the guidelines of the Honorable Apex Court in the above case, comma, it is clear that, comma, the evidence of the material witness cannot be discarded mere on the ground that they are related to the deceased, full stop. This is in such circumstance, comma, on overall reappreciation of the evidence available on record, comma, we are of the considered view that the prosecution has proved the accused is the perpetrator of the crime, and perpetrator of the crime, full stop, of the crime, and is responsible for the homicidal death of the deceased in the matrimonial, in the homicidal death of the deceased, full stop. The next paragraph. As far as the alternative contention raised by the learned counsel for the appellant, that full stop, raised by the full stop. The full stop on perusal of the impugned judgment passed by the trial court, comma, the trial court, comma, the session judge convicted the accused for the offense 302 and sentenced him to undergo till his last breath, full stop. This last breath, full stop. This sentence imposed by the learned session judge is not sustainable under law as per the law laid down by the Honorable Apex Court in the case of Union of India versus Sriharan alias Murugan and others, reported in 2016, volume 7, SEC, in para 1, held that awarding of the special category sentence, comma, in substitution of death sentence, that is sentence barring remission under CRPC for specified term beyond 14 years, comma, or life imprisonment barring remission for rest of life, comma, held is valid, clarified that, however, power under Article 72 and 161, which is not the same as the statutory power of remission, comma, is not affected. Award of non-remittable specified sentence or life imprisonment barring remission for rest of life held not violative of separation of powers. Such special sentence, when imposed under substantive provision of IPC, does not overlap procedural power under CRPC, either considering crime situation in particularly nexus between the hardened criminals and ill-gotten wealth, comma, and nature of heinous crimes on the rise, bracket close, delay in disposal of cases and balancing interest of victims with those of convicts. Such specially category sentence is necessary. Further held that such a special category sentence can only be imposed by High Court or Supreme Court and not by the trial court, full stop. In such circumstance, the said sentence imposed by the trial court not sustainable under law. Coming to the alternative submission made by the learned counsel for the appellant, that this case falls within the ambit of section 3, exception 1 to section 300 of IPC, comma, on careful perusal of the evidence available on record, including exhibit P8, the complaint lodged by the deceased herself, comma, it could be seen that the deceased being the wife of accused, comma, accused being the husband of deceased, comma, was the habit of consuming alcohol, and on the fateful day also he entered the house at about 7 p.m. By consuming liquor, and thereby a sudden row erupted between the accused and his wife deceased. Full stop. When he demanded money to consume alcohol. At that time, the deceased advised him not to indulge such act. As such, enraged by the same, comma, he poured kerosene from the bottle and set her ablaze in the chimney by the help of chimney lamp. Full stop. In this fact and in such circumstance, the Honorable Apex Court in the case of Duraram Nirmalkar versus State of Chhattisgarh, reported in 2023, volume 12, SCC 541, by referring the case in KM Nanavati versus State of Maharashtra, reported 1961, SCC online SC 69, held in para 12, Madam, 12, 13, 14, 13 to 18. 13 to 18. On careful perusal of the dictum laid down by the Honorable Apex Court in the by applying the dictum laid down by the Honorable Apex Court in the above judgment to the fact and circumstance of this case as discussed supra, comma, circumstance of this case, comma, we are of the view that the entire incident caused in a spur of moment in a grave and sudden provocation, list deprived of the self-control by the accused, based on the row erupted between the accused and deceased. Full stop. Further, the deceased also sustained for a period of 18 days after the incident. Full stop. In such circumstance, we are of the view that the accused appellate accused made out a case to modify the sentence imposed by the trial court for the offence 302 of IPC to exception 1 to section 300 of IPC, which is punishable under section 304 part 1 of IPC, full stop. However, the sentence imposed by the trial court for the offence punishable under section 498A IPC is just and proper for the reasons discussed supra, by the evidence by placing the evidence of PW 4 to 8 by the evidence of PW 5 to 8. Full stop. In that view of the matter, for the foregoing reason, comma, we modify the sentence. we modify the sentence for the, we allow for the foregoing reasons, comma, the appeal partly succeeds and we answer, we answer the point, accordingly, we answer the point raised above, that is point number 1 in the negative, and point number 2 in partly affirmative, partly affirmative and proceed to pass the following order. One, the criminal appeal so and so is allowed in part. The judgment of conviction and order of sentence imposed by the session court, imposed by the so and so court, by the court in SC number 102 of 2016, dated 21/8/2021, filed from the offense 302 of IPC through to 304 part 1 of IPC, 304 part 1 of IPC, full stop. The accused full stop on full stop. The study ಅಲ್ಲಿ how long is in custody?
My lord,
9 years.
as on today, he's 9 years, 4 months and 17 days, man.
The accused is sentenced for the period he has already incarceration, that is 9 years, 2 months.
9 years, 4 months and 16, 17 days. 4 months. 4 months.
4 months
And 17 days.
and
What
17
is-
days as on date, full stop. As on day, full stop. Additionally, he shall pay a fine of rupees 2 lakhs. In default of payment of fine, he shall undergo simple imprisonment for a period of 2 years. 2 years. 2 years for the offense 304 part 1 of IPC. Next, the sentence imposed by the trial court for the offense 498A of IPC is kept intact. Next, on depositing the fine amount or undergoing the default sentence, comma, the accused shall be released from the center shall be released if he is not required in any other case. Full stop. Next, if the fine amount is deposited by the accused before the trial court, comma, the learned session judge is directed to intimate the same to PW 5 and 6, the parents of the deceased, and disperse the same to them equally on due identification.
Yes.
Due identification. Ashte.
Yes.
My lord, in submission, my lord. The appellant happens to be a coolie by occupation, my lord, and since 9 years he's inside, 2 lakhs is very exorbitant, my lord. Right, maybe what reduced to just 1 lakh, my lord. My humble submission. And also, my lord, he is more than 65 years of age as on today. And there is ailing mother who is just more than 80 years. And 2 kids are yet to be married.
What? Yet to marry. Once again, marriage. You divorced your first wife. You murdered your second wife. Now you are preparing for third marriage.
No, my lord. No, my lord. My first wife has died out of cancer. ಈಗ ನಾನು ಇವಳ ಮದುವೆ ಆಗಿದ್ದು.
You undergo simple imprisonment for 2 years if you are unable to pay.
No, my lord. 2 lakhs is too exorbitant.
Deceased will get at least some financial this one. Help. No, you have to pay that.
Lordship, one humble submission. In morning, we had moved a memo. In that rate appeal number was wrong due to oversight, your lordship. So demolition matter, rate.
One submission.
Tomorrow, madam.
Which appeals have to be
Tomorrow, Salim Aurdu.
set.
Sir Babu.
That has been prepared. And one more.
ಬನ್ನಿ ನಿಮ್ಮ ಹೆಸರು ಮರ್ತು ಹೋಗಿದೆ. ರೆಡಿಯಾ ನೀವು? ನಿಮ್ಮ ಹೆಸರು ಏನ್ ಹೇಳಿದ್ರಿ? ಕುಮಾರ್ ಮಿಸ್ಟರ್ ಕುಮಾರ್, ಏನ್ ಫುಲ್ಲಿ ರೆಡಿ ಆಗಿದ್ದೀರಿ? ಅಲ್ಲಿ ನಾಳೆ ಮಾಡ್ತೀರಿ? ನಾಳೆ ಬೆಳಿಗ್ಗೆ ನಿಮ್ಮ ತಗೊಳ್ತೀವಿ, ನಾಳೆ ಮಧ್ಯಾಹ್ನ. ರೆಡಿಯಾಗಿ ಬರ್ಬೇಕು. ಸಿನಾಪ್ಸಿಸ್ ಮಾಡಿದ್ದೀರಿ? ಸಿನಾಪ್ಸಿಸ್ ಬೇಕಾದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಮಾಡ್ಬೇಕಾ? ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ ನಾಳೆ. ಜಜ್ಮೆಂಟ್ಸ್ ಕೂಡ ತರಬೇಕು. ನಾನು ಕೇಳ್ತೀವಿ ನಿಮ್ದು. ಆಯ್ತು.
My lord, just one more submission. ನಂದು ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ಸ್ವಾಮಿ, ಅದು if the date may be informed, then I will be ready with that with the case also. Serial number something. Then I'm ready with that matter.
ಇವ್ರದ್ದಾದ ನಂತರ ತಗೊಳ್ತೀವಿ. But next week.
Obliged. Highly obliged.